do anything when you're in. Hey, the camera needs to be turned around.
This has to go. Turn it back.
Dang it. How do I flip my camera?
Under settings.
Front camera, back camera. There we go. All right, here you go. Hold this for me.
I do it out there because
I am. I'm about to leave. So, guys, what's going on is they're in the other courtroom because we will be doing the trial here. And they're going to get their instructions for this morning's trial in the other courtroom. So when they bring them in here, we will have the jury. So just bear with us a little bit. I'm going to be doing this from my cell phone and a handheld. And then once we come in the courtroom, the other courtroom will be here with the setup like you've seen throughout the trial. So just through the beginning, we're going to be shifting a little bit. So let me go ahead and head that way. All right, I'll be back, guys.
I remember I had a case up there on the so I was up in federal court, and that Wednesday was in Idaho County regular. They used to have a 70s couch in the back of the courtroom. So I just remember walking in there going,
the courtroom in Mountain Home County still has cowboy hatbacks.
That's it. I had a court one time up in Boundary County, right up there next to the Canadian border, and it felt like you needed your 6 shooters on it.
You do?
But you know, those federal courthouses, that is really.
You're probably better at it.
Yeah.
That's rolling.
Sit up here.
Just one. Yeah, so they got federal courthouses, Boise, they used to have up in Moscow.
I think it's okay.
Moscow's about 30 miles from there. And then
It's backwards.
and they
You want to go out and check? Oh,
Is everybody hearing okay?
And I had sentencing up there one time. They got canceled. And I said,
I'm going to YouTube and ask if everybody's hearing okay.
yeah. And you know what? My plan.
You probably are.
And it turns out there was nothing I could do.
just have an on button. If you hold it, I'll go check.
Hey, everybody, if you'll tell me if you are hearing
They will let you know.
the judge and everybody okay. This is just for this part of today, and we'll be going to the other courtroom, so please let us know. We'll get this figured out. We're just going to get their instructions, and then we go into the main trial. So just let me know. It'd be amazing.
Oh, yeah. You remember back?
It's inverted.
Well, and you mentioned that, but I remember we had a room full of people, and we had to turn off the AC
Back camera.
while we were doing jury selection.
Yes, they can hear.
It sounded like,
Oh, it's horrible.
it sounded like a helicopter taking off.
It sounded like a helicopter.
And so we would take a break, and I would have them crank down the AC so we could kind of lower the, lower it a little bit, and anyway, we don't, you know, first world problems, I totally understand. We are extremely happy and pleased with you, so I'm glad that you got to see us. All right, let's go ahead. It sounds like we're ready. Let's go ahead and go on the record. We are in session in Mass v. Brashier, CD 35-23-195. James Brashier, we're having Brashier and Mass are present. Council table, the plaintiffs are present together with their attorneys at council table. Ladies and gentlemen, my purpose today is just to start the conversation. It sounds to me like we are getting close to the end in the sense that I believe you represented yesterday, Mr. Miller, that you had one final witness to call your case in chief. Is that correct?
That's correct.
All right. And we think that will probably be through this morning.
Yes.
And then Mr. Brashier, Ms. Brashier Mast, once they rest, I'm going to allow you to present your case. And I seem to recall you had 3 or 4 witnesses that you intended to call. And I imagine we'll be through with the testimony portion of the trial today. Is that a fair
I
statement?
believe that we will.
All right. So it's possible that we may be in a position where instructing the jury this afternoon, they're deliberating. That being the case, on your tables today, I brought in and I got, again, jury instructions. These are my best attempt. I know that both parties suggested by number some of the AGs or the civil jury instructions. I didn't get a submission of complete jury instructions and how they apply to the parties, so this is what I've been working on. I will note for you that instructions 1 through 6 are the pre-proof instructions. Those have already been given. So the post-proof instructions start at number 7. And then I've got just some notes at the bottom for you to take a look at. And so I wanted to get your thoughts on those. And again, you haven't had a chance to look at these. The other issue that I have brought up based on the fact that one of the exhibits that was entered yesterday is a certified copy of the judgment of conviction for Mr. Brashier for voluntary manslaughter based on a criminal trial. I think that brings up the potential issue of claim preclusion. I provided counsel and the parties a copy of the case that addresses that. That's the Anderson versus City of Pocatello, 112-5-176. So I have, if you look at mine, again, and I'm not married to this instruction, but
which number is that?
number 14 is the one that I have looked at. And again, this is my attempt. I don't know if you plaintiffs are asking for this, but it reads as follows. You are instructed that the defendant, James Brashier, in this case, has been previously convicted in a criminal proceeding of the offense of voluntary manslaughter for causing the death of John Mast. In this case, the defendant's prior conviction for voluntary manslaughter conclusively establishes the following facts, which you must accept as true. One, that the defendant, James Brashier, engaged in unlawful conduct that caused the death of John Mast. Therefore, for purposes of this case, you must find that the defendant, James Brashier, committed an actionable wrong against John Mast, and that same wrongful act caused his death. You must determine what damages, if any, should be awarded to the plaintiff, Robert Mast, as a result of that wrongful death, based on the evidence presented at this trial. Again, that is my stab in the dark at this. Below that, just in the notes, I have provided for you the criminal jury instruction, the pattern criminal jury instruction for voluntary manslaughter. Those are the elements that the jury found beyond a reasonable doubt in the criminal trial. And I'm looking particularly at element 3, which is that the defendant engaged in conduct which caused the death of the decedent, in this case John Mast, and element 4, the defendant acted unlawfully upon a sudden quarrel with due to passion and without malice of forethought causing such death. Agreed. So, again, Mr. Miller, this is just, again, like I said, I spent a good portion of the weekend looking at this, and I spent a good portion of yesterday evening considering this. So I'm not married to this. I don't know if you're asking for this, but I do think, given that there is evidence that admitted that the defendant has been convicted of voluntary manslaughter, it's an issue that we need to discuss. So,
Appreciate you bringing this up, good, and forewarning us yesterday, I will admit to the court that I was a little paranoid about the court's forewarning yesterday, that perhaps it was going to affect our claim adversely somehow, this issue of claim preclusion. I didn't see how it applied at first, thinking that it might be an issue that we wouldn't be able to bring this claim. So, I guess, tit for tat, Judge, I spent a good part of my life researching this issue last night as well.
well, I didn't see I'm in good company.
That's right. But no, I think that the instruction as presented here is fine, except we would ask that the portion where it starts in bold, collateral, stop,
Right.
not be.
Right, those are, and again, I'm providing, those are just some of my notes, so you would, obviously that would be cleaned up when they go in front of the jury. So, you're gonna see throughout these instructions, there'll be a note, this is plaintiff's requested, this is defendant's requested. Those are notes for me and for us so that we can talk about that. That will all be cleaned out, obviously, before any of those signatures, so we won't have any of that. But again, this is just so that we can have a conversation about how that happens. Now, the other thing that I wanted to bring your attention to with regards to the wrongful death claims, as I reviewed the statute, I think the plaintiff who is entitled for a claim of wrongful death is the father, Robert Mast. I did not hear any evidence from the siblings that they were wholly or partly dependent on Mr. Mast. So I think under Idaho code, they are not proper plaintiffs to make a claim as to wrongful death. So I think the wrongful death claim pertains only to the parent, Robert Mast. Am I?
We agree, Judge, that's my understanding of the law as well, that the wrongful death claims, both of them belong to Robert. The emotional distress claims belong to Stephen and Betty, although I think the argument could be made that those also apply to Robert, but definitely Stephen and Betty who were there in the zone of danger.
And you'll see that in the, I think we're on the same page, and the reason I looked into that is because I know that the defendants were objecting to, I think, wrongful death claims as to the siblings, and that was, I think, the thrust of some of the proposed exhibits that Ms. Brashier, Mast, and Mr. Brashier had hoped to be. I think the law supports your objections to wrongful death claims as to Betty Troyer and Stephen Mast. So at this point, I'm going to disallow those, but we are going to move forward with the wrongful death on behalf of Robert Mast. And so, anyway, Anderson versus City of Hotel, that's the case, I think, that talks about conclusion. So we can, if we have we're going to have to see how the rest of the proof obviously plays out today. But I think that's where I'm at. And again, I'm not married to the idea of giving instruction 14. I only threw that in there simply because I think that's an issue. I don't know if the defendants are going to object to that. Again, this is just a very preliminary discussion on jury instructions. And so I haven't received any other than what you have submitted to me at this point. So moving on to, for example, the fifth one. That one talks about, I've got the plaintiff Stephen Mast and Betty Troyer have claims of negligent infliction of emotional distress against James Brashier.
Misspelling there, Judge, Brashier. Just
Oh, thank you. I appreciate that. I will make that note. And then again, as I indicated below, and that's just my note that this is your requested, but modified to reflect 2 distinct claims in the state, the plaintiff's burden.
Okay.
Instruction 16 relates to the intentional infliction of emotional distress, and again, this is proposed instruction 16, and these could be renumbered just as we get through this. But that's to reflect that there are 2 separate claims with 2 separate defendants.
that was on the
17 is just, when we talk about negligence, we've got that potential negligence instruction that just defines what negligence is. 18 is just was the duty of the defendant James Brashier before and at the time of the occurrence to use ordinary care for the safety of the plaintiffs. I'm not sure if that needs to be modified, but
Your Honor, can we go back to 16?
you may.
And what if claims of negligent infliction of emotional distress, which requires showing a physical injury or mechanical patient and claim for potential infliction, has no such requirement? Can you explain that to me a little bit?
That comes from, I've got the 2 case sites down there,
Okay.
and I want to say that was plaintiff suggested that, so.
Okay.
Yeah, negligent claim, there has to be some sort of manifestation. The read of the case law is that
Got it.
intentional and does not.
Okay.
Again, Ms. Brashier, we're not
Understood.
making any final decisions right
Okay,
now.
thank
This
you,
is
understood.
just to make you aware of these, and what I'm gonna do is, before we have our formal jury instruction conference, I'm gonna actually look into these, but, so these are why there's some of these notes there for you, just for your.
Okay. Thank you, Your Honor.
19 reflects Ms. Brashier Mast requested instruction. Here.
Throughout, we, again, we can have a more formal conference on this later about this. I think that the evidence has shown and will show that Ms. Brashier also committed negligent infliction of emotional distress with her action. And so I don't think we agree with the instruction 19 or the way 18 is worded as well.
Okay, I'm going to just make a note of that.
Okay.
Again,
I object to that.
well, and I know I will recognize that objection. What we'll do is we'll have a further discussion on that. So again, nothing is going to get set in stone right now, but I just want you to be aware of these as we go through them. So Mr. Miller, you had proposed the gross negligence instruction 20 was your request number 5 talking about gross negligence. I've got that in there because you requested it.
Well, we left them for now.
Okay. And then 21 was your instruction with regard to willful and wanton as you said instruction. I don't know that I see those terms in the instruction, so I just wanted to alert you to that.
Kid, there's we can move this through now.
Perfect.
It'll make more sense in the future.
Okay, that makes sense because again, one of the reasons I say that is I didn't get the traditional package or instructions that I'm used to getting. I got like if you want to whatever, and then I got 2 of them. But so I was left guessing how this was going to relate. So I was like,
Those you can print it out. Give it to the
oftentimes what I get is instructions that are specific to the case at hand, and so which is fine. But this is why when I saw this instruction with regard to willful and wanton, I wasn't sure what that was referring to. But I'm not going to take it out at this point. It sounds to me like they may have some relevance later on, and I'll allow you to look at that.
Thank you.
Yes, sir.
Instruction 25, what does that mean?
We'll get that. Okay. And that I'm glad you brought that up because that's another one that I'm to a certain extent shooting in the dark because nothing was proposed to me on that. But hold your thought on that just for a second. We'll be right there. 22 is the approximate cost. Both parties requested this one. 23. So when we look at 23 and 24, the question I had is in the pattern jury instructions, there appears to be a damage instruction as to wrongful death, and then there appears to be a damage instruction just as to general damages.
Right.
And so 23, it appeared to me that this was the general damages one, which, again, I'm shooting in the dark here because I wasn't provided anything to the contrary. But it seemed to me that 23 would relate to claims for negligent infliction of emotional distress, intentional infliction of emotional distress, or potentially a civil liability for death by a firearm. And so I've got that bracketed and in bold just to have that discussion. I can say there's not much out there that I can find. And then that is, as you compare that to 24, 24, I think I just added in the first sentence is the pattern, other than I added wrongful death just to make sure that we clarify that this is the general instruction for wrongful death under IGE 9.05. So let's think about that, put that on the burner, and I want to just bring you to that attention. Okay. 25 is the question from Mr. Brashier. In the complaint, Mr. Brashier, the plaintiff alleges damages pursuant to Idaho Code 18-3307. And I'm just going to read that statute to you. Idaho Code 18-3307 is entitled Civil Liability for Injury by Firearm and reads as follows, quote, any party maimed or wounded by the discharge of any firearm aforesaid, or the heirs or representatives of any person who may be killed by such discharge, may have an action against the party offending for damages which shall be found by a jury, and such damages when found may in the discretion of the court before which such action is brought be doubled. That's the code section that they have alleged damages under. And so again, Mr. Miller, I didn't see any kind of a proposed jury instruction as to that, but my review of the statute, I think the jury's got to make a finding that somebody was killed or maimed by the discharge of a firearm, and they have to make a finding that somebody did that. And once that finding is made, I think they assign damages for that. Again, this is a statute that there is no case law on. So
I found the same thing, Judge. And if we could take just a minute on that, please do. So my take on this, my reading of this, when I looked at it again last night, is that I agree with the court. I think that the jury must make a finding that the party, in our case John Mast, was maimed or wounded, doesn't say killed, but I think that would be included, by the discharge of a firearm. Right? I think they need to make that finding, I agree. However, it looks to me like the damages portion is actually reserved to the court rather than the jury. It says here that that party may have an action against the party offending for damages which should be found by a jury, and such damages when found may in the discretion of the court before which action is brought to be dealt. I guess this could be read two different ways, I suppose. The way I read it last night is that we bring an action for wrongful death. They find that the death was caused by a firearm. They award damages for the wrongful death. Then at the end of the trial, if it's found that the death was caused by a firearm, the court can double those damages.
And I saw that, and I wondered, though, whether it is a separate line item from wrongful death. In other words, are we dealing with damages from wrongful death, separate damages for negligent infliction, separate damages for intentional infliction, and then a fourth line item of separate damages for use of a firearm? I don't know. So I agree with you that
It could be,
I'm sorry, confusing.
it could be read that way. I mean, it could be read the way that I was suggesting, but I can also see the court's reading of it today that it does say that such, that the party can bring an action against the party offending for damages which shall be found by a jury. And then the court doubles those. So I guess I can see that separate line item of damages for the jury as well. And then if they find damages for this, then the court can double those at the end.
Right.
So, yeah, I can see both ways.
Okay. Food for thought. Let's maybe put a pin in that, but I wanted to alert, again, that was Ms. Brashier, Mr. Brashier, that's 18-3307.
Thank you, Your Honor.
Could you say that again?
You bet. Idaho Code 18-3307 is the code section. And I agree with Mr. Miller, when I looked and when my staff attorney looked, there is no case law. That statute has been on the books 1972, and it looks like it originated in 1907. And it says that the same words as the section read prior to its repeal. So I think that's been on the books for 118 years now. And as far as I can tell, my research has shown that there's nothing out there. It's been mentioned a time or two. What I can tell is it's a very common allegation to put into complaints. But I think somebody said it, and I thought said it well, that less than 1% of cases still facing now, I think, proceed to trial. So it doesn't surprise me that there's no real case law on this. So anyway, I bring that to your attention. 25, again, that was my attempt to just reflect an accurate statement of Idaho law. 26, again, is somewhat similar to the previous instruction 14, which reads as follows: you are instructed that the defendant, James Brashier, in this case, has been previously convicted in a criminal proceeding of the offense of voluntary manslaughter for causing the death of John Mast. In this case, the defendant's prior conviction for voluntary manslaughter conclusively establishes the following fact, which you must accept as true: 1, defendant James Brashier caused John Mast's death. Therefore, for purposes of determining civil liability for causing death by firearm, we must find that the defendant, James Brashier, caused John Mast death. Your role as jurors is to decide whether James Brashier caused John Mast death by discharge of a firearm. If you find that he did, you must then determine the amount of damages, if any, that should be awarded to the plaintiffs based on the evidence presented during this trial. I mean, and that's just my shot in the dark on that. I'm not married to that wording. Again, this is just Judge Monson trying to figure out a problem. I didn't have a lot of guidance from the parties coming into it, so I'm hoping that maybe you provide me some guidance before we go to the end.
That's our plan, Kenny.
Good, all right.
Although we're not opposed to this.
Yes,
Okay.
we're not.
Anyhow, that's 26, and then 27 is just my standard AG or the standard jury instruction with regard to damages. I give you instructions on the subject of damages. I do not express any opinion as to whether the plaintiff is entitled to damages. At 28, what I traditionally do in cases like this is I provide a jury instruction that outlines how the jury verdict will go. This is subject to change. It just goes through each of the questions, and we can talk a little bit more further about that. You may need some time to kind of, it's kind of an algorithmic process to go through.
Right.
But again, depending on what we do with those, that may change. And again, 29 is 29, 30, 31, and 32 are just standard simple instructions. Yes.
Can I ask about this question? Did the defendant, Rebecca Brashier Mast, commit an actual wrong against the decedent John Mast?
Yes.
Is that question clear enough?
So that relates to, if you look at the elements of instruction for wrongful death, and that is.
Because that could mean,
Judge, if I may, for a second, please.
Please do.
And I know the defendants are not attorneys, but I'm thinking this is becoming a nightmare for our court reporter. The defendants are talking over the court, talking over other people, and if they could just wait until someone finishes talking before they start talking.
So I understand Ms. Brashier, yes, I understand your question. And so if you look at kind of the proposed instruction 12, that outlines the elements for wrongful death, which is 1, an actual wrong was committed by the defendant against the decedent, and 2, that actual wrong caused the decedent's death. So the questions asked to you, the jury needs to find, the jury's going to be asked to answer yes or no, did you commit an actual wrong against John Mast? And number 2, if so, did that actual wrong cause John Mast's death? So that's, in order to find liability as to you for wrongful death, they have to answer those 2 questions yes. And so that's why I designed it there, because I'm going to ask them, did they do that? Now, right now with regard to your father, James Brashier, because he was convicted of voluntary manslaughter, right now my thinking is I would give an instruction that we call that collateral estoppel or claim preclusion, because the jury's already determined that he caused the death of John Mast and that his action was unlawful. With regard to your father, the question is going to be what damages, if any, are established because they've already established, and the prior jury's already established and mitigated the issue of whether he did it or not. Does that make sense?
yes, Your Honor.
But you haven't had that same opportunity, right? And that's what we're here for
Yes, sir.
today. And so we're going to be asking the jury, yes or no, did you do something, and if so, did that cause the death? That's the shorthand reason for those 2 questions. But that's a good question.
Thank you,
Appreciate
Brad.
you bringing that up. All right. So, again, my intention is once we close with evidence, I think we're of necessity going to need to take a somewhat lengthy pause in order to further discuss this. And I wanted to give you at least a copy of these, so that this is really the working copy. There's nothing set in stone. But I wanted to give you at least my thoughts where we're at right now on this and give you an opportunity to do that. And then Ms. Brashier, Ms. Brashier, I've also, with regard to that claim preclusion, what we were talking about, I wanted to make sure everybody got a copy of Anderson versus City of Hotel, which I think is the case that talks about why that may be an issue. I suppose, gentlemen, you could tell me, you you don't want that, you want to just have the jury ask straight up or down. You tell me you don't want a plain conclusion instruction, but I certainly prefer you to think about that.
Certainly, Judge, and to let you know, Judge, Mr. Miller and I will try to work when we can to get to that point so we don't, to shorten our discussion.
Understood. So, okay. We're at 8:48, so we're about 10 minutes shy of starting court today. Anything else that we need to take up before we go back in? And it sounds to me like the next witness would be Mr. Brashier.
That's correct. A couple things, again, in an effort to be fully transparent with the court, wanted to let the court know that at the conclusion of evidence, when we take that lengthy break, we'll talk about instructions and other things, I plan to bring a motion to reconsider the court's ruling on the punitive damages issue.
Understood.
And I've got an argument to make.
Understood. Appreciate you letting me know.
You got it. And then we talked yesterday, Judge, about defendants and their plans going forward with their case in chief, and obviously they get to make a case in chief, of course, and call witnesses and get that. We're wondering a little bit, though, defendant Ms. Brashier Mast brought up the idea, I think yesterday or the day before, of recalling Jenny Troyer and Stephen Mast. She had an opportunity to fully cross-examine them. I guess we'd like to know, excuse me, ahead of time, what issues she wants to get into with them, where she already had a chance to explore all of their testimony with them.
Ms. Brashier, Mass.
I would have to look at my notes. It's in my notes at this point.
Appreciate that, and I think that's a point well taken. If we get to that point, let's have a discussion outside the presence of the jury.
Yes, Your Honor.
And we can make that call.
Your Honor, in a similar vein, I don't know if Ms. Brashier Mast intends to call herself in the stand as a witness, but yesterday, after she was cross-examined, or examined, I guess, as a hostile witness on my partner, the court allowed her then to present a narrative. Is the court going to allow her to present a second narrative, where she's already had that opportunity?
I think she's entitled to call herself as a witness. You know, cross-examination, she, for lack of a better term, cross-examined herself yesterday. It would have been, I think, related to the questions on direct exam. Now, again, I'm aware of the fact that on direct exam, we covered a lot of ground. I don't know what we left uncovered. But at this point, I don't think I can preclude her from calling herself as a witness, nor do I think I would preclude Mr. Brashier from calling himself as a witness, although the court would be mindful that in doing that, we have covered a lot of ground already. So I don't think I can stop you, and I don't plan to stop you, but I want to make sure everybody's aware that we have covered a lot of ground.
I've written something out that I'll just simply read and keep it within the parameters.
And then similar to my instruction yesterday is I am going to allow you to testify in a narrative form like you did. I'm going to ask you to go slow, and then if there is an objection, I'm going to ask you to stop until we clarify the objection, in particular because it may be something that we need to take up outside the presence of the jury.
Yes, Your Honor.
But I appreciate what you're saying, but I think plaintiffs have a right, or excuse me, defendants have a right to call their case, and I don't know if they've got something else that they want to discuss that may not have been covered yesterday.
Understood, Judge. Thank you. Lastly, along with this same issue, it's my understanding, it's my experience in court, that witnesses are not allowed to have things in front of them to refer to unless their memory is being refreshed by that document, or they're being handed an exhibit to refer to. We would ask that same thing be applied to the defendants here when they call themselves as witnesses.
And I think that's fair. So to be transparent, I guess, from the bench, if there is a paper or something that you're referring to, I think that the other side has an opportunity to review that. So
Absolutely, I have a document that I would be refreshing my memory with, and I would have them also view that document as well.
all right. And we'll take that up, but again, I want you to be aware, if you bring something up there to use, I think
Yes,
the other
Your
side, the plaintiffs have a
Yes.
right to see what you're using. Okay?
Yes, Your Honor.
Okay, anything else?
Judge,
Yes, sir. Mr. Hickey.
it had been indicated yesterday that Ms. Robin Brashier may have been called as an expert, and I think the court kind of withheld the kind of ruling on that to see what happened with the people that we had testified. We didn't, as the court knows, we didn't certify anyone as an expert. We did an expert testimony. So if she's planning to do that, we'd like to kind of take that up now instead of having that argument in front of the jury.
And I watched that closely. I do know that some of the officers, two of the officers, talked about their professional experience and those things that informed, to a certain extent, their opinions. I agree that they didn't offer any what we would traditionally call expert opinion, but I do think that they were using some of their training and experience that they talked about to visit about that. I mentioned that I was going to try to be fair on this. I think if Ms. Brashier, Master Ms. Brashier calls Robin Brashier, I think they can ask her about her experience, her background, like the plaintiffs did. I want to be very careful that she's not to offer any expert opinion in terms of that, but I certainly think that can inform why she may be taught things.
Judge, can we inquire as to what she, well, I guess first of all, is she planning to use her mother as an expert? I guess we'd like to, I think we're entitled to know that.
As a grandmother, and what she viewed in the home and how she viewed things. I actually have a bit of an issue myself with how the expert, how the plaintiffs represented their yesterday. I mean, I'll keep it within the parameters of how they utilized their witnesses yesterday.
Well, there were some indications in some of the pretrial filings by the defendants, and I can't remember where I saw it, but I just don't want Robin Brashier trying to go into, well, the children told me this, and here's my opinion on what they were saying. I just don't think that's appropriate, and I don't want that blurted out.
Right.
Just being frank.
And that is hearsay. One of the disadvantages of not having an expert witness. Experts can rely on hearsay, and so they can rely on things that the kids said and told them. I'm not going to allow testimony that the kids told me this, therefore I thought that. Now, if she wants to say something along the lines of these are my observations and I've got this experience and that informed my thought, that's a different thing. That's along the same vein, I think, of what the officers were talking about. But I'm not going to allow her to come in and say, based on my training and experience, I listened to the kids' complaints, and because I'm an expert, I've got this expertise.
Yes, sir.
This is why I believe that. So she's not going to be able to rely on what the kids told her, because that's hearsay. She hasn't been qualified as an expert. Mr. Miller?
No, I anticipate the defendants will have Robin talk about her experience as a nurse. And that was brought up through some of the exhibits that they wanted to admit. And I guess we don't necessarily have an objection with that as part of her training and experience, or who she is. However, if they start to get into things like, well, that makes me a mandatory reporter, and I have to report these things, I don't think that's fair game. Based on what the court has decided already.
I think that's a big slope. The lady that was Casa in Washington, she said pretty much the same thing.
I think, here's something, if I may, we're already down this road quite a ways, but this occurred to me yesterday that I'm going to present the closing argument when we get there, and I'm going to explain to the jury, this may be confusing already as to why John Mast is on trial in this trial. A large portion of this trial has seemed to be about John Mast. The defendant herself even brought this up yesterday. And my point to the jury tomorrow during closing is going to be the only reason we've had to do that is because of allegations that they've made, not just prior to this trial, but in their pleadings. That they have brought up this issue in their answer to our complaint, raising this issue of John Mast, and we felt like we anticipatorily needed to address those things. Otherwise, we really shouldn't even be talking about all this stuff, right? Our fear, frankly, is that the jury, that they may pollute the jury's mind into thinking there's some kind of self-defense here available to them, or Mr. Brashier at least, for what he did to John Mast, because what John Mast allegedly did, right? So the only reason we're even talking about this is because they raised the issue in the pleadings. Otherwise, I don't think any of this would even be appropriate to get into. This is not a trial about John Mast. It has become that. I don't think it should have, but this is a trial about what these two people did, the evil acts and atrocities that they committed. We shouldn't even be talking about John Mast. So they should not be allowed to be getting into it any more than they already have.
So the question I have for you, Ms. Mast, is if your mother, Robin Mast, testifies, does she intend to testify, the kids told me this and I took actions based on that?
Your Honor, I believe that she would testify that she observed fear in children, that she witnessed actions with the children that pertained to her concerns. Those are the sort of things that she would testify to.
And that's very different from testifying, the kids told me this and therefore I did this. And that's what I think Mr. Miller and Mr. Hickey are asking me to prove, which I'm prepared to do. Now, if she's gonna come in and say, I'll tell you my observations, I think that's fair.
Yes, and her training does play into that, just like Sergeant Daniel Hendricks' training plays into it. That plays into it. I am gonna ask her about the letter that I received, because she was part of that situation.
Which letter was that?
That would be,
Is that an exhibit? Was that what
it was
you're-
an exhibit. And I also intend to testify about that as well. It was addressed to me from Williams County.
No, that's which exhibit was that?
I believe it was exhibit,
Oh, exhibit H.
Yeah, I
Exhibit
can't
H.
remember the letter, then, but I think
I
it
do
was
see
just
that.
allowed.
no, let's not disallow. It was
Yeah.
admitted.
I reserved on that. I haven't said anything about that, but the question I have though is,
Am I allowed to give that during my, testimony?
so, one of the reasons I reserved on that is because, unlike the other ones, where there was no witness who could authenticate it or lay the foundation, so there was no way that was going to come in. This was a little bit different in the sense that this was addressed to you. But that was only one part of, I think, the plaintiff's objection. The other part was that it contains hearsay, which is an out-of-court statement used to prove the truth of the matter asserted. And so, well, in theory, you say, I got a letter, that's a different thing from saying, I got a letter that said, which is where I expected I'm going to have a hearsay objection from.
Am I able to say I got a letter and then read it aloud?
No, not at this time, unless there is an exception to hearsay, because what I hear, the other side, and again, I recall this from yesterday, if I'm not mistaken, is it's hearsay. I hadn't said no yesterday, but
That's correct, Your Honor, and I think even though she did receive it or will testify she received it, I think the letter is still hearsay, and then as the court has pointed out, there's also hearsay statements in the letter. So that it's problematic, we do object to it. If I can address briefly, I think Ms. Brashier, she's trying to combine Robin Brashier and Daniel Hendricks in the same kind of boat, and they're not. Daniel Hendricks was appointed to this case and was the lead investigator of this case. Robin Brashier was no part of any investigation of this case. She is not, so unless she was some kind of expert, I don't think she can be giving opinions on that.
And that leads me to the question, was Daniel Hendricks considered an expert witness? He just said that she was the lead detective in the case. He's putting her in an expert position with his testimony that he just gave.
That's not correct. She's more of a lay witness because she's actually involved in what's going on and dealing with the facts of these allegations and investigating.
You just gave her an expert
Yeah, but she was not
testimony.
paid.
well, and again, Um, The other issue is, I didn't hear any objections during her testimony. And so, and again, this is one of the difficult things about representing yourselves. I indicated at the beginning that, and Mr. Brashier, I know that you have audibly reacted every time I make a decision that doesn't go your way. And I've heard you do that, and I just heard you do that a moment ago. And the reason I'm bringing that up is because at the beginning, at the outset of this case, one of the things that I told you, one of the perils of being self-represented is that you're expected to know the rules of evidence, you're expected to comply with the rules of evidence, and you're held to the same standard as these two gentlemen are over here who are licensed attorneys. Generally speaking, I would say that puts you at a great disadvantage, but I am not able to favor you or cut you any slack, I guess, for lack of a better expression, simply because you're representing yourselves, because that would be unfair to the other side. And so I know you disagree with my rulings. I perceive that you don't like the hearsay rulings that I'm making, but they're based in law. They're based in the and I will tell you that hearsay is a very complicated area of law. We spend a whole class in law school talking about evidence, and I don't know what your experience was, but my experience was probably half of that related to hearsay.
Shelley, my wife, had the hardest time with hearsay.
So it is, and so that's why I understand, and that goes to my next comment to, Ms. Brashier Mast. Can you testify you received a letter? Sure.
Yes.
That's not hearsay. That's something that you received. But what you have in this letter, again, hearsay is defined as it's an out-of-court statement used to prove the truth of the matter asserted. And so what they're telling me is what you want to do is use the statements in here to prove exactly what they are. And that's the definition of hearsay, and I'm going to sustain this objection right now. I'm going to sustain that objection right now.
Can I testify to the contents of the letter without submitting that letter or reading it out loud?
How do you intend to do that?
I intend to simply make mention of the letter and testify to its contents.
Your Honor, I think our question would be, what do you mean by testify to the content?
Right.
I would just simply say that I received the letter and it replied to the services required for sexual abuse of Shira as well as psychological maltreatment of John Mast.
That's the same objection. It's just basically then reading the hearsay. And Judge, I also feel like we're almost getting to a point of almost counseling the defendants on how to get evidence in. I think that's a little bit of an issue.
Again, you can talk about receiving a letter. I don't think you can talk about the contents of the letter. I think that is hearsay, and I think that's appropriately objectionable. I'm going to sustain that objection. You can talk about, because I received this letter, I took these actions. That's fair game.
I can do that.
Yeah, but I'm not going to let you read the letter, or you can't talk about the contents of the letter. You mentioned that there is a letter, and that you received a letter, and as a result of that letter, you move in the direction next lawyers. Okay.
Okay, Your Honor.
Okay. Anything else?
I think that covers what we had to do.
Okay. Again, I think we're going to probably. I think we're going to be in a position where we be through with Mr. Brashier by the new hour.
Oh, I think so.
Yes.
Okay.
Yeah.
So we may be in a position where we're calling witnesses this morning, Mr. Brashier and Ms. Brashier. So I just want to leave that. Okay. All right. We'll go ahead and reconvene in courtroom 3. Appreciate everyone's attendance.
Judge, when we get into the, only just a minute to get set up technically.
I'll give you a minute to get set up and then.
Thank you.
It's attached.
I think he.
Maybe get the rooms.
Yeah.
Step right into it. All right, well, let's go ahead and go on the record. We're in session in the case of Mast v. Brashier, Nez Perce County case CV 35-23-195. Plaintiffs are present at council table with their attorney. Mr. Brashier and Ms. Brashier-Mast are present at council table as well. We are outside the presence of the jury. We haven't returned them yet. I know that we had a meeting in Courtroom 4 earlier today to discuss some pretrial matters, but other than what we've discussed, counsel or parties, are there anything that we need to take up just briefly before we return the jury?
No, Your Honor.
All right, let's go ahead and rise for the jury. Thank you. Okay, please be seated. Thank you very much. All right. When we left off, welcome back, everybody. I'll let the record reflect the jury is back. It looks like they're properly seated. Will the parties stipulate that the jury is returned and properly seated?
Yes, Your Honor.
Good. All right. Thank you very much. Ladies and gentlemen, welcome back. We appreciate your patience this morning. When we left off last evening, the plaintiffs were still presenting their case. Mr. Miller, I'll allow you to call your next witness.
Thank you, Ron. Plaintiff's called James Brashier.
Mr. Brashier, if you'd come forward and face my clerk and be sworn.
Do you affirm under the penalty of perjury that the testimony you will give in this matter shall be the truth, the whole truth, and nothing but the truth?
Mr. Brashier, I'm going to have you take a seat, make yourself comfortable. And when you're ready, I'm going to have you state and spell your name for the record, please.
James, James, Brashier, Brashear.
Thank you. Ladies and gentlemen, are you able to hear Mr. Brashier? All right. We're going to ask you to speak up. You've got the benefit of a hearing assistive device, so I'm sure you can hear yourself very well. But if you can just be aware of the jury and speak up, I'd appreciate that. Mr. Miller, you may inquire.
Thank you, Your Honor. Before I begin, Your Honor, permission to treat this witness as hostile.
You may.
Thank you. Mr. Brashier, I'm going to take you to first the events just a little bit prior to the day of the killing of John Mast and point your memory in the direction of your criminal trial in August of 2023. Do you remember that criminal trial?
Your Honor, I refuse to answer that on the Fifth Amendment, Savage versus the state.
I'm going to overrule that objection. I think having testified at the criminal trial, you have waived your Fifth Amendment right. Or in a civil trial, I am going to instruct you to answer those questions.
Does that mean I can't use the Fifth Amendment?
Mr. Miller, what's your position on the Fifth Amendment?
Oh, Your Honor, I don't think it applies here. He's already been convicted. There's no danger of incrimination. I'm not going to ask him about anything other than what he was already tried for. There's no danger of being retried for that. He's convicted. Fifth Amendment doesn't apply. Oh, yeah. Actually, his appeal has already been denied by the Supreme Court.
But it's also being taken to a higher court, and I have an attorney. Is that process right? Yes, ma'am. Yes.
Frankly, Your Honor, I will say this, if I could. I don't think it applies, and I'll let the court deal with that how it will. On the other hand, I don't really care if he wants to take the fifth on everything. I think the jury is allowed to consider that in their deliberations if that's what he decides to do. I think they can draw their own inferences in a civil case
by him. In fact, there's case law that states that if he takes the fifth in a civil case, they can draw inferences from that.
Mr. Hickey, did you want to add anything to the
Yeah,
discussion?
if that's okay with the court.
Please.
I did a little research on this, and I think while the appeal was pending, it was a little murky whether he could claim the fifth or not. But now that the appeal is over and his conviction's upheld, I don't think he has that right. But that's just my position.
My clerk is telling me I don't have the remitter yet from the appellate court, at least not in our.
We do have the order. I don't know, in Arkansas, it's called a mandate. That may be a remitter here.
Your Honor, it is an unpublished opinion. However, it is from the Court of Appeals of the State of Idaho, if I may approach.
You may. What date is that, do you know? Looks like it was filed June 30, 2025. Let me do this. I am going to take a brief recess. I want to take a quick look into this before I issue a final decision. Ladies and gentlemen of the jury, I need to check something. So I'm going to excuse you back to the jury room so you can be comfortable. You're going to take your morning break a little earlier than we thought, but I need to share this with you before we do that. So members of the jury, I remind you that you're not to discuss this case among yourselves or with anyone else, nor to form any opinion as to the merits of the case until after I finally submit the case to you. I will be back to you as soon as I can. Please rise for the jury. Please be seated. I'll be back with you as soon as I can.
Moved it. Perfect. Thank you. Yep.
Let's go ahead and go back on the record. This is Nez Perce County case CV 35-23-195, Mast et al. V. Brashier. Defendants, Mr. James Brashier is present on the witness stand at this point. Ms. Rebecca Brashier Mast is present at counsel table. The plaintiffs are present at counsel table along with counsel. The issue, we're outside the presence of the jury. The issue that came up that I wanted to double check is a situation where Mr. Brashier has invoked his Fifth Amendment right to remain silent in the civil proceeding. What was unique about this situation is that in his criminal trial in August of 2023, he waived that right to remain silent and testified. And the question the court had was whether a waiver in that criminal trial would carry over to a civil trial, and the court's considered opinion at this point is it does not. If he wants to invoke the right to remain silent, he can do that. I'm looking at a number of cases, one of which is C&M Investment Group Limited versus Campbell, 164 Idaho 304. It discussed this issue, and I'm just going to quote from that decision. It says, quote, "The Fifth Amendment provides that no person shall be compelled in any case to be a witness against himself. It is well settled that the right extends to civil proceedings where the answers to questions might incriminate the individual in a future criminal proceeding." And that's citing Lefkowitz versus Turley, a U.S. Supreme Court case, 414 U.S. 70. And it goes on to say, a witness protected by the privilege may rightfully refuse to answer unless and until the witness is granted immunity from the use of the compelled answers in any criminal case in which the witness is a defendant. Now, I'm not aware of any criminal case in which the defendant is a defendant at this point, but I can see potential issues where there may be concerns, for example, perjury, whether some testimony he gave or gives today may be different, and that could result in a future criminal prosecution. So, and again, that references throughout the case law that I saw. So I am going to allow him to continue to invoke his Fifth Amendment right. Now, that said, Mr. Miller, I think, is correct that the invocation of your Fifth Amendment right in a civil case carries some implications. In particular, I'm looking at a case of Idaho Department of Health and Welfare versus Doe, and that is 151 Idaho 300. And that case indicates that we note, I'm going to say, quote, "We note that it is generally permissible in civil cases to make inferences against someone who invokes her Fifth Amendment rights." And I think that's where Mr. Miller was getting at. And that is citing another U.S. Supreme Court case, Baxter versus Palmgiano, 425 U.S. 308. And so I think that's the legal lay of the land. I think if Mr. Brashier wants to assert his Fifth Amendment right, I'm going to allow him to do that and allow him to refuse to testify. So, Mr. Brashier, I'm going to allow you to do that. But again, to be clear, I think that opens the door to Mr. Miller requesting some sort of instruction that the jury can draw negative inferences from the right to refuse to testify pursuant to the case law that I've got. Ms. Brashier, Mast, do you have any comments or anything else that you want to add? Mr. Brashier, anything else that you want to add? Okay. Do we need to have Mr. Brashier remain on the witness stand at this point?
Yes.
Yes, Your Honor, and I think you hit on what I was going to bring up at the end. We may want to craft a jury instruction about the adverse, but we can deal with that later.
All right. How do you intend to proceed? Do you intend to ask him questions and allow him to invoke his Fifth Amendment right, or what's your?
That's exactly right, Judge. And we will, to be candid with the court, we will also be using portions of Exhibits 8 and 9, Plaintiffs 8 and 9, as part of the question.
Okay. The other thing I would note is trial testimony from his criminal jury trial is not hearsay, as you're well aware. So
correct.
I'm not sure if you intend to make any use of that, but I'm aware that it exists. I don't know if there would be an objection, but I think it's pretty squarely not hearsay under the rules. So
Agreed. Thank you, Judge.
All right. Anything else that we need to take up before we return to jury?
No, Your Honor.
Any suggestion on how I pursue? I think what I'm going to do is, when they come back, I'm just going to let them know that I have looked into it, and he is entitled to invoke his Fifth Amendment right, and I'll just leave it at that.
I think leave it at that, and then
Okay.
we can talk about instructions later.
We can do that later. Okay, very good. Please rise for the jury. All right, thank you. Please be seated. All right. Ladies and gentlemen, the jury, I note that you are back. You are seated properly. Will the attorneys stipulate and the parties stipulate that the jury has been returned and is appropriately seated?
Plaintiff stipulate.
Very good. All right. Ladies and gentlemen, welcome back. We took a short recess so that the court could tackle a legal issue that has presented itself. I've been able to conclude, based on the research that I've done, that Mr. Brashier is entitled to invoke his Fifth Amendment right at this time, and so I'm going to allow him to do that. So, Mr. Miller, that being said, you may continue to inquire.
Thank you, Your Honor. So, Mr. Brashier, I'm going to ask you this question again since we've had this delay. You remember your criminal trial from August of 2023, correct?
I would impose the Fifth Amendment on that.
You remember that at that criminal trial in August of 2023, you testified in your own defense.
I would take the Fifth Amendment on that.
Your Honor, we request the witness to speak up if he can.
Yes,
Would you mind speaking up? Thank you very much.
it's difficult.
I understand. It's going to come through more loudly because you have the earpiece on than it will for the rest of us. So,
Mr. Brashier, you remember that at that criminal trial, when you testified, you were under oath.
I'll take the Fifth under that, Fifth Amendment on that.
You understand that you're under oath today.
I would take the Fifth Amendment on that.
Just to be clear, you don't understand that you just took an oath just a minute ago to tell the truth today. Is that what you're saying?
I'd still take the Fifth Amendment on it.
At your criminal trial, you recall that your attorney, Mr. Bugbee, Christopher Bugbee, questioned you about the events of February 5th, 2021.
I would take the Fifth Amendment on that as well.
He asked you in that criminal trial related to that, that if, when you woke up that day, Friday, February 5th, 2021, if you had any reason to believe that your two grandchildren would be spending any unsupervised time with John Mast over that weekend.
I would impose the Fifth Amendment.
When he asked you that question, if when you woke up that day you had any idea John Mast would get unsupervised visitation, when he asked you that, you said, not at all, wasn't a concern.
I'll take the Fifth Amendment on that.
He asked you as a follow-up, was that in any way, even within the realm of your imagination, referring to unsupervised visitation? He asked you that. You recall that?
I would take the Fifth Amendment on that.
Your response was, I'd think it was impossible. You recall?
I'd take the Fifth Amendment on that.
And yet, on February 4th, the day before the murder, you sent Rebecca, your daughter, a text message about the custody exchange the next day, correct?
I'd take the Fifth Amendment on that also.
If I show you Exhibit 3, that is your text message to your daughter, will you take the Fifth on that?
I would take the Fifth Amendment on that.
All right, I'm not going to bother showing you that exhibit. It's already been admitted and the jury can look at it. Since you're refusing to answer any questions about it?
I'm standing on the Fifth Amendment, sir.
Okay. in that message, actually, Madam Clerk, could I have Exhibit 3 for just a moment? Plaintiff's Exhibit 3 is a copy of this text message that you sent to your daughter, Rebecca, on February 4th in the evening, the day before the killing. In that document, you ask her, did you say the original document said John would pick them up at 6 p.m. tomorrow? You recall sending that?
I'll take the Fifth Amendment on that.
All right. Do you deny sending that?
Take the Fifth Amendment on that.
I'll take that as a no. So when you said in this text message, did you say the original document said, you're talking about the court's final divorce order that was issued the December prior, just a couple of months before, December 14, I believe, where John Mast was granted unsupervised visitation beginning first weekend of February, correct?
Take the Fifth Amendment on that as well.
That's the original document you were talking about that granted John unsupervised visitation, correct?
I take the Fifth Amendment on that, sir.
Okay. You go on to say, so you reference this original document that you are aware of, this divorce decree that gives him unsupervised, and then you say, did the original document say that John would pick them up at 6 tomorrow, correct?
I take the Fifth Amendment on that, sir.
Meaning, there's nothing in this text message about supervised visitation, correct?
Take the Fifth Amendment on that as well, sir.
As a matter of fact, it says John would pick them up. Now, when John had supervised visitation, he didn't pick them up, did he?
I take the Fifth Amendment on that as well.
He went to Dynamic Family Connections in Clarkston with Ashlyn Wiesa and had his visitation supervised by her or one of her employees, correct?
I take the Fifth Amendment on that, sir.
So when you say would pick them up, you knew that John Mast was entitled to unsupervised visitation. He was going to pick those kids up and take them somewhere.
I'll take the Fifth Amendment on that as well.
You knew that the day before you killed him.
I'll take the Fifth Amendment on that if it's a question.
You knew strike that. Therefore, because you knew these things, based on this text message that you sent Rebecca, you knew that there was an original document, a divorce decree granting John unsupervised visitation, and you knew that John was going to pick those kids up. Knowing all of that, therefore, when you told your attorney in your criminal trial, you had no idea that unsupervised visitation was going to happen that day. That was a lie. Correct?
Is that a question, sir?
That's a question.
I'll stand on the Fifth Amendment.
You lied to the jury in your criminal trial when you said you had no idea that unsupervised visitation was going to happen that day. Furthest thing from your mind, that was a total lie, because the day before you told your daughter that you knew about the original document and John was going to pick them up, correct?
I'll take the Fifth Amendment on that.
All right. Let's move on to the day of the murder. On February 5th, 2021, that day, you and your wife drove down from Winchester and you dropped her off at work in Lapway.
I'll take the Fifth Amendment on that.
Is that because you're taking the fifth on that question about driving your wife down because you're afraid that's going to incriminate you in some proceeding?
I'll take the Fifth Amendment on that.
All right. You then met Rebecca for breakfast or lunch at a diner.
Take the Fifth Amendment on that, sir.
Because that's incriminating, correct?
I'll take the Fifth Amendment on that question.
All right. Now, during that meal with your daughter, Rebecca, you got a phone call, or Rebecca got a phone call, excuse me, from her family law lawyer in North Dakota that all efforts to stop John's unsupervised visitation had failed, correct?
I'll take the Fifth Amendment on that, sir.
Rebecca's attorney told her, you were sitting there with her when she got the call, right?
I'll take the Fifth Amendment on that.
Rebecca's attorney told her that if she did not take the kids to the exchange, she would likely be in contempt of court, right?
I'll take the Fifth Amendment on that as well.
Because of that, you and Rebecca then spent the rest of the business day running around Lewiston trying to find some way to stop the visitation.
I'll take the Fifth Amendment on that, sir.
You were frantic to stop that visitation.
Take the Fifth Amendment on that, sir.
Rebecca was frantic to stop that visitation.
I'll take the Fifth Amendment on that also.
You ran to CPS trying to get help from them. You ran to a counselor to get help from her, I believe. You ran to the courthouse trying to get a protection order, correct?
I'll take the Fifth Amendment on that.
All of those efforts to get some help to stop this unsupervised visitation, court-ordered unsupervised visitation, all those efforts failed.
I'll take the Fifth Amendment on that.
You were getting desperate.
I plead the Fifth Amendment on that.
Your daughter, Rebecca, was getting desperate.
I take the Fifth Amendment on that.
Just before 5 p.m. on February 5th, 2021, you were at the courthouse and you learned that the Idaho judge would not grant a protection order or stay of the visitation, correct?
I take the Fifth Amendment on that.
You were very angry about that, correct?
I take the Fifth Amendment on that as well.
You expressed your anger in the presence of court employees, including sheriff's deputies here at the courthouse, correct?
I take the Fifth Amendment on that as well.
After that point, you and Rebecca went back to Rebecca's apartment.
I
Right?
take the Fifth Amendment on that.
When you got there and Rebecca explained to the kids that they were going to this visitation, you claim that the kids started screaming and crying.
I take the Fifth Amendment on that as well.
That made you even more angry and desperate.
Take the Fifth Amendment on that too.
That made Rebecca even more desperate.
Take the Fifth Amendment on that, sir.
After shooting John, let's fast forward to after you left Rebecca's apartment and went to Rosar's. After shooting John, you calmly waited in the Rosar's parking lot for police to arrive. And when they arrived, they took you into custody, handcuffed you, and put you in a patrol car.
I take the Fifth Amendment on that.
There was an officer standing there who put you in that patrol car and then stood with you for quite some time as other law enforcement arrived and handled the scene, correct?
I take the Fifth Amendment, sir.
That officer was Officer Lines. You recall that?
I take the Fifth Amendment on that.
Officer Lines had you in the patrol car and then immediately read you your Miranda rights, correct?
I take the Fifth Amendment, sir.
And you agreed to talk to Officer Lines.
I take the Fifth Amendment on that, sir.
Since you don't want to testify about it, let's just hear it in your own words, shall we?
Counsel, is this plaintiff's exhibit 8?
This will be, yes, plaintiff exhibit 8, correct?
So here's the deal. I'm going to read you your Miranda rights, okay?
Yes, sir.
So you have the right to remain silent. Anything you say can and will be used against you in the court of law. You have the right to talk to a lawyer and have him present with you while you're being questioned. If you cannot afford to hire a lawyer, one will be appointed to represent you before any questioning if you wish. You can decide at any time to exercise these rights and not answer any questions or make any statements. Do you understand your rights?
Yes, sir.
Are you willing to talk to me today? You want to talk? I'm willing to. Okay.
And Madam Clerk, we can leave the lights down if that's all right. I've got several clips to play. At your criminal trial, your attorney asked you specifically, did you premeditate this murder? You recall that?
I take the Fifth Amendment.
You replied, absolutely not. Do you recall saying that?
Fifth Amendment.
You don't recall saying in your criminal trial, absolutely not, I did not premeditate this.
I take the Fifth Amendment.
Well, let's hear from you.
Premeditated, you know, I thought about it, weighed out the cost and, you know. It's premeditated, you know, I thought about it, weighed out the cost and, you know. It's premeditated, you know, I thought.
Can I inquire if the jury is able to hear this all right? Okay. So when you told your lawyer at your criminal trial, he asked you, did you premeditate this murder? And you said absolutely not. That was a lie.
I take the Fifth Amendment, sir.
At your criminal trial, your attorney asked you, they allege that you had an opportunity to think through what needed to be done to carry it out, maybe even weigh the consequences of causing the death of Mr. Mast. Did you have an opportunity to do those things? That was the question Mr. Bugby posed to you in your criminal trial. Do you recall that?
I take the Fifth Amendment on that.
Do you recall your answer?
Fifth Amendment, sir.
Your answer was no, sir. You had no opportunity to weigh the cost of the consequences of causing his death. That's what you said at trial. Do you recall that?
I'll take the Fifth Amendment on that.
Let's hear what you told Officer Lyons one more time.
Premeditated, you know, I thought about it, weighed out the cost and, you know. It's premeditated, you know, I thought.
So when you told your attorney at your criminal trial you did not have an opportunity to weigh the cost, that was a lie.
I take the Fifth on that, sir.
You told Officer Lyons when you were sitting in the patrol car that you got to the parking lot before John and waited for him. Do you recall that?
I'll take the Fifth Amendment, sir.
All right, well, let's play it then.
Hey, James.
Yes, sir.
So walk me through the process of, I guess, from start to finish. You get here, obviously, that's where you park right there, right?
Yeah, I guess she had agreed to meet him at the at the library box stop, right there.
Okay. So you parked your truck right here.
Parked over there, and he wasn't here.
Okay.
And I waited, and he pulled up over there.
You told Officer Lyons that as you walked up to John there in the parking lot, it looked like he was getting a car seat ready. Do you recall that?
Take the Fifth Amendment on that, sir.
Okay.
he got out of his vehicle,
Okay.
and it appeared that he was getting a car seat ready or whatever.
Say that again.
It appeared to me, he came around on this side of the van, and it looked like he was getting a car seat ready, in exchange.
You told Officer Lyons when you were sitting in the patrol car that after walking up to John Mast, saying, "Hey, John," you shot him once in the chest for sure, and then 2 or 3 more times in the back as he ran away.
I take the fifth on that, sir.
Over, and by then he was on the passenger side. His sister was behind him, or kind of behind him, but over out of the way. I didn't want to hurt her. And so he kind of got out of the, I don't know if he got out of the vehicle or just by the door, but he came to the right side of the door, and I shot him in the chest.
Okay.
That one hit. Then he took off running, and I shot either 2 or 3 more times at him, and they didn't seem to do anything.
Okay.
As if that wasn't bad enough, you told Officer Lyons, you doubled down on that and told Officer Lyons sitting in the patrol car right there that John should have dropped like a bad habit, but he didn't. Do you recall saying that?
I take the fifth on that, sir.
Let's hear your own words.
How many shots did he hit? Did he hit? Just one?
I can't comment on half of it.
He should have dropped like a bad habit, but he didn't.
Finally, as if that wasn't enough to add insult to injury, you made the unprompted comment to Officer Lyons, "I hope I didn't do all this and just wound him. That would suck." You recall saying that?
I take the fifth on that.
Let's hear your words then.
Do all this and just wound him. Hope I didn't do all this and just wound him.
At some point after this interview with Officer Lyons in the patrol car, you were formally arrested, taken to the Lewiston Police Station, correct?
Take the Fifth Amendment on that.
You were interviewed by Detective Tyler Crane at the Lewiston Police Station.
I take the Fifth Amendment on that.
That interview happened the same day as the murder, February 5th, 2021, correct?
Take the Fifth Amendment on that.
It happened within an hour after the murder, correct?
Take the Fifth Amendment on that.
Once again, even though Officer Lyons had read you your Miranda rights and you waived those rights, Detective Crane, back at the police station, also read you your Miranda rights, correct?
I take the Fifth on that, sir.
He informed you that you had the right to remain silent during that interview, correct?
Take the Fifth Amendment on that, sir.
You chose to speak with him anyway.
I take the Fifth on that.
I'm Tyler Crane, detective here with Lewiston Police Department. You said Fisher?
Brashier.
Brashier, okay. And is it James?
Yes.
Okay.
Hey, Robert.
This is my partner, Sergeant Levitt.
That's Sergeant. Glad to meet you. What's your name? Jim? Yeah. Brashier. Jason.
So it is 1903 hours. So Jim, I'm sure this has already been done, but I just like to make sure with my own eyes. So I'm going to read you your rights, okay? You have the right to remain silent. Anything you say can only be used against you in a court of law. You have the right to talk to a lawyer and have him present with you while you're being questioned. If you cannot afford to hire a lawyer, one will be appointed to represent you before any questioning if you wish. If you answer any questions now without a lawyer present, you can stop at any time until a lawyer is present, or refuse to answer any questions until a lawyer is present. Do you understand that?
Yes, sir.
Okay.
Mr. Brashier, you appear awfully calm in that interview, don't you?
I'll take the fifth in that.
Drinking a sip of water, correct?
I'll take the fifth on that.
I don't see you sobbing or crying, correct?
I'll take the Fifth Amendment on that, sir.
I don't see you in any way agitated at that point, correct?
Fifth Amendment, sir.
Now, after being Mirandized and waiving your right to talk to Detective Crane, you told Detective Crane that after exhausting all your options to try and stop John's court-ordered unsupervised visitation, you went back to Rebecca's apartment with her, correct?
Fifth Amendment, sir.
You told Detective Crane, now, this I think is important. You told Detective Crane that while at the apartment, quote, I promised my daughter that he would never have them again by himself, much less take them home. You're referring to John Mast and his children, correct?
Take the fifth on that.
We heard testimony. You were in the courtroom yesterday, correct?
I take the fifth on that.
Because that's incriminating to admit that you sat here?
I take the fifth on that.
All right. So you were here in the courtroom when we heard testimony from your daughter that you never said this. You never promised her anything about John Mast not getting the kids, correct?
I take the fifth on that.
All right. Well, let's hear what you told Detective Crane then.
I promised my daughter that he would never have them again by himself, much less take them home.
You promised your daughter that John Mast would never have those kids again by himself, much less take them home, correct?
I'll take the fifth on that, sir.
You made that promise to her the day you killed John Mast, shortly before you killed him.
I'll take the fifth on that, sir.
At your criminal trial in August of 2023, your attorney, your defense attorney, asked you, do you think of yourself as a fixer? Do you recall that?
Yeah, I take the fifth on that.
And you said, my name was the Fix-It Man. You got a problem, I fix it. You recall that?
I take the fifth on that as well.
Mr. Brashier, if I show you a copy of the jury trial transcript, which I'm holding here, and show you the very words that your attorney asked you and your words that you responded, are you still going to take the fifth?
I'll take the fifth on that, sir.
Okay. At your criminal trial, your attorney asked you about things the kids allegedly said to you about not wanting to go with John, and they said these things to you while you were at Rebecca's apartment and they were crying. Do you recall testifying that way at trial?
I'll take the fifth on that.
Your attorney then asked you, after Zane said what you agree he said to you, did you have thoughts of killing Mr. Mast?
I plead the Fifth Amendment.
Your answer, do you remember?
I plead the Fifth Amendment.
Your answer was no, definitely not.
I plead the Fifth Amendment.
In other words, the question was, even seeing the kids as you allegedly paint them, did you have thoughts of killing Mr. Mast? No, absolutely not.
I plead the Fifth.
He then asked you at trial, under oath, as you walked from the apartment and you went down and got back into the Suburban, did you have any thoughts of killing Mr. Mast?
I plead the Fifth.
You said no, sir.
I plead the Fifth.
He then asked you, under oath, when you reached over and you grabbed your pistol and you held it in your hand to put it in the center console of the Suburban, did you think of using that gun to kill Mr. Mast?
I plead the Fifth.
Your answer was never even considered it. No, absolutely not.
I plead
Unquote.
the Fifth.
Your attorney asked you while you were under oath, as you sat in that Suburban, after you parked your car and you saw Mr. Mast, did you form an intent to take his life?
I plead the Fifth, sir.
You said no.
I plead the Fifth.
He asked you further, when you got out of your vehicle and started to move toward Mr. Mast, so apparently he's asking you about when you were in the Rosar's parking lot. You're there, you've waited, you lied in wait for John, you're waiting for him, you see him. Your attorney says, when you got out of your vehicle and moved towards Mr. Mast, did you form an intent to kill him?
I plead the Fifth.
You said no.
I plead the Fifth.
All right, let's hear what you told Detective Crane.
Long story short, while she was packing up to take the kids over there, I showed up and I decided I was gonna kill him. Long story short, while she was packing up to take the kids over there, I showed up and I decided I was gonna kill him.
You showed up to her apartment while she was packing for the kids. You decided you were going to kill him.
Plead the Fifth, sir.
At that point, having made that decision, you moved your gun from your car to Rebecca's Suburban.
I plead the Fifth.
Okay.
So did you have to move the gun from cars, or did you take the car that had the gun in it?
I had to move, I took my gun with me.
Okay. So where did you carry it then? Did you carry it on you, or did you carry it in the car?
I put it on the seat of the right seat of the car.
You told Detective Crane in this interview that you always carried a gun, and Rebecca knew this. Correct?
I plead the Fifth.
Okay.
I have a concealed weapons license, so I'm always carrying it. See, if I told her that, she'd say so, and I live in Winchester, I mean, everybody carries it there. But I do have a concealed weapons license.
Sure.
If I told her I had a gun, she wouldn't think any of that.
Yeah.
If I told her, meaning Rebecca, I had a gun, she wouldn't think anything of it. That's what you said, correct?
I plead the fifth.
You intentionally switched vehicles with Rebecca, correct?
Plead the fifth.
I dropped my wife off at work in Lapway with my wife's vehicle, and I had errands to run today. And Becky and I went out to eat for breakfast and stuff. And the plan is for us to switch vehicles, and we take the Suburban back while we get it fixed.
You already told Officer Lyons in the patrol car that you got to Rosar's before John Mast and waited for John to arrive, correct?
Take the fifth.
But then you told Officer or Detective Crane the very same thing, correct?
I'll take the fifth.
And then I waited until he drove up. I went over and shot him.
Okay.
Is there anything else you need to know about? And then I waited until he drove up. I went over and shot him.
Okay.
Is there anything else you need to know about?
When John, you told Detective Crane that when John arrived and got out of his car, you walked up to him, hiding the gun in your.
I plead the fifth.
So when you showed up at Rosar's,
Yeah,
where did you have the gun?
right to the car, but
And then when you got out,
had it in my hand behind me.
so and then you just had your hand walk right up to him with it in your hand.
Yes, sir.
Okay.
Well, behind, you couldn't see the gun.
You walked up to John with the gun behind your back and you said, "Hey, John." And then when he turned to face you, you shot him in the chest at point blank range, correct?
I plead the fifth.
You told Detective Crane all that, correct?
I plead the fifth.
I said, hey, John, and he come out past the door, and that's when I shot him.
Okay.
Then he took off running, and I followed him and shot a few more in his back. But
Okay.
like I said, I don't think they did anything. Maybe they did, I don't know.
Once again, Mr. Brashier, you appear awfully calm when you're stating these things to Detective Crane. Would you disagree?
I plead the fifth.
You tell him, I shot him in the chest. You shrugged your shoulders. I shot him again in the back. I don't know. Is that what you said?
I plead the fifth.
You don't seem in any way agitated when you're telling him this story, do you?
I plead the fifth.
You were only about 4 feet away from John when you shot him the first time, correct?
I plead the fifth.
So how many times would you say you?
I think, I know I shot him once in the chest, and I think 3 times at the back, I think.
Okay. Tell me about how far away you were.
When I shot him in the chest, I was probably 4 feet from him.
Okay.
When I shot him, I started running. I shot him a few more times in the back.
In that interview, you told Detective Crane that after killing John, you texted your wife, Robin, and told her it's done. Do you recall telling him that?
I plead the fifth.
All right. Let's hear what you told Detective Crane about that.
After I shot him, I went back to the vehicle. I called my wife, told her what I did. And of course, but she does mean all that. And I texted her well, I texted her first and said it's done.
Your Honor, may I approach the witness?
You may.
Mr. Brashier, I'm handing you what's been marked as Plaintiff's Exhibit 4. Do you recognize what that is?
I plead the fifth.
I will proffer to you, Mr. Brashier, that this is a copy of the text message that you sent to your wife, Robin, that you just described to Detective Crane in that interview. Do you disagree with that?
I plead the fifth.
I would proffer to you that this is an accurate copy of the text message that you just described to Detective Crane. Would you disagree with that?
I plead the fifth.
I would also remind you that this text message was admitted into evidence in your first-degree murder trial. Do you recall that?
I plead the fifth.
Your Honor, we would move for admission of Exhibit 3 at this point.
Ms. Brashier, Mast, do you have any objection at this point?
I do not have any objection.
I think you meant 4, is that correct?
Did I say 3?
I think you said 3.
Sorry, Exhibit 4, yes.
With regard to Exhibit 4, Ms. Brashier, Mast, you don't have any
I
objection?
have no objection.
Mr. Brashier, do you have an objection?
I do not.
All right, so Exhibit 4 will be admitted.
Thank you, Your Honor. Your Honor, may I retrieve?
You may.
And just to save a little bit of time, Your Honor, can I publish this by just handing this to the jury?
You may.
Thank you. You told Detective Crane that this message that the jury's looking at right now was something you sent your wife on February 5th, immediately after killing John Mast, correct?
I plead the fifth.
And the jury will see in that exhibit that, according to military time, that text was sent at 5:57 p.m. February 5th, correct?
I plead the fifth.
And if we convert that to standard time that we understand, that would be 5:57 p.m., right?
I plead the fifth.
Okay. After telling Detective Crane about texting your wife, you also told Detective Crane, I killed him, I hope. I hope I did kill him. I'm going to do time for it. Do you recall telling Detective Crane that?
I plead the fifth, sir.
Let's hear your words then.
I have nothing to lie about. I killed him. I hope I did kill him.
Mr. Brashier, when you say that, do you get choked up?
I plead the fifth.
Do you cry?
I plead the fifth.
Do you seem anxious or upset?
Plead the fifth.
Or do you seem awfully calm and cold-blooded right there?
I plead the fifth.
At your criminal trial, your attorney, after walking you through the events of February 5th, 2021, before the shooting, he asked you, did you have any thoughts about fixing this situation by killing Mr. Mast while you stood in the courthouse that day? Do you recall that?
I plead the fifth.
Your answer was none at all. You recall that?
I plead the fifth.
He then asked you, what about as you sat out in the car and Becky was saying, we have to turn the kids over, did you have thoughts about killing Mr. Mast at that time? Correct?
I plead the fifth.
Your answer was no, absolutely not. Correct?
I plead the fifth.
And yet, in your interview with Detective Crane, you told him that you wanted to kill John. Correct?
I plead the fifth.
Okay.
So you said a minute ago, I mean, you wanted to kill him, right? Is that, okay.
You told Detective Crane that you had thought about killing John probably 100 times before actually doing it. Correct?
I plead the fifth, sir.
And I want to be honest with you, I thought about it 100 times.
You told Detective Crane that you had said out loud several times prior, well, I'll just kill the dirty bugger. Do you recall saying that?
I plead the fifth, sir.
I will say this, like I told the officer, several times I said, well, I'll just kill this dirty bugger. And
You told Detective Crane that, quote, if you ask around, somebody might say, well, he told me he was going to kill him. You recall telling Detective Crane that?
I plead the fifth, sir.
so yeah, if you ask around, somebody might say, well, he told me he was going to kill him.
Now, Detective Crane asked you specifically in this interview, when was the last time you said anything like that? You'll kill him, or you want to kill him, or you want him dead, to Becky. Do you recall Detective Crane asking you that?
I plead the fifth, sir.
Your answer was, he said, when was the last time you talked about killing John to Becky? You said, probably today. Correct?
I plead the fifth.
Yeah, when was the last time you said anything like that, that you'll kill him, or you want to kill him, or you want him dead, to Becky?
Probably today.
Okay.
At your criminal trial, your attorney asked you, when you came out of Becky's apartment and you got into the Suburban, where was the gun? Do you recall being asked that?
I plead the fifth, sir.
And you told your attorney at trial, under oath, it was on the passenger seat and I had secured it in the console. Do you recall that?
I plead the fifth.
Your attorney then asked you at trial, why did you move it from the passenger seat to the console at that time? You remember that?
I plead the fifth.
You said, I don't drive with a gun on the passenger seat. It's not safe.
I plead the fifth.
So where did you carry it then? Did you carry it on you or did you carry it in the car?
I put it on the right seat of the car.
And so when you showed up at Rosar's,
Yeah.
where did you have the gun?
Right seat of the car, but
So when you told your attorney that you had put the gun in the console, that was a lie, correct?
I plead the fifth.
You told Detective Crane and his counterpart, the other policeman there, you had the gun on the passenger seat of the Suburban the whole time.
I plead the fifth.
You bragged about being safe with guns.
I plead the fifth.
You bragged that I wouldn't be unsafe with guns. I'd definitely secure that in the console, correct?
I plead the fifth.
Your attorney asked you at trial, your criminal trial, did that, being safe with firearms, does that mean a lot to you? Do you recall that?
I plead the fifth.
And you said, oh, yes, correct?
I plead the fifth.
And yet, you admitted to, calmly, by the way, calmly admitted to Detective Crane here that despite what you told your attorney in trial, despite the fact you were under oath, you told Detective Crane here that you had the gun on the passenger seat the entire time as you drove to Rosar's, even though you admit that's not safe. And then on Friday, February 5, 2021 at 6 p.m., you opened fire in a crowded parking lot of a busy grocery store with members of the public all around you and the victim's sister 2 feet away from him behind him. And you claim that you're a safety gun advocate.
I plead the fifth.
When you shot John Mast, where were the kids?
Can you repeat that, please?
Does it matter? When you shot John Mast, where were the children?
I plead the fifth.
The kids were with Rebecca, weren't they?
I plead the fifth.
When you shot and killed John Mast, the kids were not in the Rosar's parking lot.
I plead the fifth.
When you killed John, the kids were not with John.
I plead the fifth.
When you murdered John, John was not sexually abusing his kids.
I plead the fifth.
When you murdered John, John was not abusing his kids in any way.
I plead the fifth.
When you killed John, Rebecca was not present.
I plead the fifth.
When you killed John, John was not abusing Rebecca.
I plead the fifth.
When you killed John, he was not threatening you.
I plead the fifth.
He was not threatening you physically.
I plead the fifth.
He was not threatening you verbally.
I plead the fifth.
He was not even armed.
I plead the fifth.
He had no weapon.
I plead the fifth.
You snuck up with his back turned to you, the gun behind your back, and surprised him in an ambush like a coward, didn't you?
I plead the fifth.
When after you shot him in the chest, point blank, and he ran trying to save his life, you shot him again in the back like a coward. Correct?
I plead the fifth.
You served in the military, didn't you?
I plead the fifth.
You're proud of your military record, aren't you?
I plead the fifth.
That's not what you're taught to do in the military, are you?
I plead the fifth.
In fact, you testified already that when you told Officer Lyons that right before you shot him, he was arranging the kids' car seats, correct?
I plead the fifth.
You shot an unarmed man at point blank range while he was making his car safe for his kids.
I plead the fifth.
The kids that you claim to love.
I plead the fifth.
I've got one more thing for you, Mr. Brashier. Toward the end of the interview with Detective Crane, you said there's probably no good reason for killing somebody, correct?
I plead the fifth.
There's probably no good reason for killing somebody.
You told Detective Crane there's probably no good reason for killing somebody, correct?
I plead the
It's
fifth.
finally something we can agree on. That's all I have.
Thank you, Mr. Miller. Ms. Brashier, Mast, do you have any cross-exam questions for Mr. Brashier?
I do not.
Mr. Brashier, I'll give you an opportunity to respond if you'd like.
No, thank you, Your Honor.
Thank you. You may take your seat. Thank you.
Thank
You
you.
may step down. All right. Mr. Miller, Mr. Hickey, you may call your next witness.
Your Honor, the plaintiff's rest.
Very good. I'll give Mr. Brashier a moment to take a seat. I'm going to allow,
Thank you, Your Honor.
take your time. Okay. Mr. Brashier, Ms. Brashier Mast, the plaintiffs have rested. Mr. Brashier, I'll allow you to call your first witness at this time.
I wish not to speak to the witness.
I'm going to allow you to call a witness on your behalf if you would like. You have,
I don't want to call a witness.
are you resting your case?
Yes, sir.
All right, thank you. Ms. Brashier Mast, I'll allow you to call your first
Mr.
witness.
Honor, is there any way we could have a brief recess?
We may.
To use the bathroom
We may.
possibly?
Why don't we take, let's take 10 minutes,
Thank you.
and then we'll come back and I'll have your witness ready, will you?
Thank you so much.
All right. Members of the jury, I remind you that you're not to discuss this case among yourselves or with anyone else, nor to form any opinion as to the merits of the case until after I finally submit the case to you. Please rise for the jury. Okay, thank you. Please be seated. I'll see you back. We'll get started at 11:15.
still have that note out that you took on. Show me.
Oh,
Yeah, on the notes, just that note that you took.
yeah.
If you could read it. All over the place.
All right. Let's go ahead and we'll be back on the record. This is the matter of Mast v. Brashier, Nez Perce County case CV 35-23-195. Mr. Brashier and Ms. Brashier Mast are present at council table, defense table. The plaintiffs and their attorneys are present as well. We are outside the presence of the jury. Before we return the jury, is there anything we need to take up at this time?
I believe so, Judge.
And Ms. Brashier, who will be your first witness?
James Brashier.
All right. Let's go ahead and rise for the jury. And Mr. Brashier, hang tight just for a second, and we'll bring it back up. I need to go buy a lottery ticket because I got to tell you, that's about the fourth time I've caught somebody in the restroom. It's pretty good odds. We will have a new break. Sounds to me like the Rolling Thunder was upstairs moving vending machines in, so I mentioned that we are a work in progress in the building, so yet another audio issue that we're through.
For clarification, I guess, and I don't know if this needs to be on the record or not. Are we on the record? No. I don't know if this needs to be, but for clarification, did Mr. Brashier say that he is not calling any witnesses?
Correct.
Okay. Thank you.
We are. All right, thank you. Please be seated. All right, record will reflect that the jurors have been returned. They appear to be properly seated. Will the parties stipulate that the jurors have been returned and are appropriately seated at this time?
Yes, Your Honor.
Yes, Your Honor.
All right, very good. Thank you. All right, ladies and gentlemen, where we are just before your break, the plaintiffs rested their case. Mr. James Brashier rested his case. And so now I am turning the time over to Ms. Rebecca Brashier Mast to present her case in chief. Ms. Brashier Mast, you may call your first witness.
I will call James Brashier Sr.
Okay. Mr. Brashier, if you'd come forward.
Your Honor, I may need some help with setting up for screen sharing that they were doing
Okay.
before. I don't know quite how to do that.
I will make my clerk available to you. I think she
Thank
can
you. I
probably help
appreciate
out.
that.
All right. Before you sit down, Mr. Brashier, I am going to have you face my clerk and be placed under oath.
Do you affirm under the penalty of perjury that the testimony you will give in this matter shall be the truth, the whole truth, and nothing but the truth?
Thank you. You may be seated. And Ms. Brashier Mast, you may inquire.
I don't have it in this.
Just Nate internet.
Do you not have internet access? Is that the,
Is there an internet password here?
I don't know the answer to that. Do you have an ability to plug in an internet cable?
I believe so.
Let me do this. I'm going to take just a brief moment. I'm going to step off the bench, go alert my trial court administrator. I think this is what we were talking about yesterday, so I'm going to give you this, although I'm going to have you rest in place here. I'm not going to send you back to the room. Members of the jury, I remind you that you're not to discuss this case among yourselves or with anyone else, nor to form any opinion as to the merits of the case until after I finally submit the case to you. Feel free to stand up. You can stay seated. Make yourself comfortable. I'm just going to run and I'll be right back.
Your Honor, I'm just gonna go ahead and have the plaintiff refresh his memory and read it, if that's
Okay.
okay. Just
That's
to make
fine.
it more simple.
This is my deputy
That's
trial
what I'll have him
administrator.
do. It's fine.
All right, we're happy to give any tech support you need.
I appreciate it very much.
Okay.
Not to be a false alarm, but I'll not waste the
All
court's time.
All right, let's go back on the record. We are back on the record in Brashier, or excuse me, Mast v. Brashier, CV 35-23-195. Again, the jury remains seated. I note that they did not exit the courtroom while we took a very brief recess. Plaintiff's counsel and plaintiffs are present. Ms. Brashier Mast is at counsel table. Mr. Brashier is on the witness stand. Will the parties agree that the jury is back and properly seated?
Yes, Your Honor.
All right. That said, Ms. Brashier Mast, you may inquire.
Okay, thank you. Did you attend hearings in North Dakota which discussed John Mast's disorderly conduct charge?
Repeat that, please. One moment. Please repeat that.
Yes. Did you attend hearings in North Dakota which discussed John Mast's disorderly conduct charge?
I don't remember.
Okay. Did you also attend hearings in North Dakota which discussed the abuse of Ashira and Zane Mast?
I don't remember.
Okay. Would you recognize this form from the memorandum of opinion, findings of facts, conclusions of law, and order for judgment?
Repeat that, please.
Would you recognize this form of memorandum of opinion, findings of facts, conclusions of law, and order for judgment?
I don't know.
Let me bring this over to you to see if it refreshes your memory. Go ahead and feel free to read that out.
I'm not going to allow him to read it out loud. He can read it to himself, but I'm not going to allow him to read it out loud.
Okay.
Your Honor, may I remind the court that I do have laws of short-term and
Well,
long-term?
I'm going to have you
Okay.
respond to your daughter's question. Thank you.
Okay, I'm sorry. I don't remember this.
You don't. You didn't always go with me to every visitation, correct?
Again,
Did you go with me to every visitation? Or did other people occasionally go with me as well?
I don't believe I went to every one of them, no.
Did I also take various vehicles?
Yes,
On February 5th, 2021, you originally came into town to fix my brakes, correct?
that's right.
Objection leading.
Sustained.
I will rephrase. Was your intention to fix my brakes on 2021?
Yes,
On February 2021, did you have any expectation that there would be an unsupervised visit planned until a phone call from my attorney? Correct?
Objection leading.
sustained.
I'll rephrase. On 2021, did you have any expectation that there would be an unsupervised visit?
I don't remember.
Was that phone call at the diner?
Was what?
Was that phone call at the diner?
I don't remember.
Okay. Did I in any way participate in a supposed plan to kill John Mast?
No.
Where were you living when this incident occurred?
Mr. Brashier, you're. That's fine.
Say that again, please.
Where were you living when this incident occurred?
In Winchester, Idaho.
Was I living independent from you at that time?
Yes, you were.
Did you have a concealed carry permit?
I did.
Did you always keep your weapon on or near you?
Most of the time, yes.
Did you have a driver's license?
Yes, I did.
Finally, did you act alone?
Pardon me?
Did you act alone in the plan to kill John Mast?
Yes.
Did I ever threaten to harm John Mast?
Not that I know of.
No further questions.
Thank you. Mr. Miller or Mr. Hickey, cross-examination.
Mr. Brashier, you'll answer any question your daughter poses to you, but you won't answer any of mine?
I plead the Fifth
That's
Amendment.
okay. Thank you.
Ms. Brashier, miss, any questions on that? And I'm going to be very careful. That's a very narrow question.
No, Your Honor.
Okay. Mr. Brashier, before you step down, you have a right to cross-examine yourself. Is there anything that you would like to say?
No, there is not, Your Honor.
Very good. You may step down.
Thank you. Okay.
Ms. Brashier, Mass, you may call your next witness.
Thank you.
Here's that she's going to locate her witness. Guess I'll just have the record reflect that she has exited the courtroom and appeared that she was looking in the two interview rooms to locate a witness. Ms. Brashier, Mass has returned.
I'm calling Robin Brashier.
Very good.
She's on her way.
All right, Ms. Brashier, if you would please come forward, face my clerk, and I'm going to have you placed under oath.
Here?
No, anywhere you're comfortable. Just face my clerk just for a moment.
Okay.
Do you affirm under the penalty of perjury that the testimony you will give in this matter shall be the truth, the whole truth, and nothing but the truth?
Yes, I do.
All right, thank you. And ma'am, I'm going to have you come forward to the witness stand. Take a moment and make yourself comfortable.
Thank you so much.
I'm going to share with you what I've been sharing with all the witnesses. We are learning about the acoustics of this new courtroom, so I need you to speak loud and clearly so that the jurors can hear you. And to test that, I'm going to ask you to state and spell your name for the record.
My name is Robin Brashier, Robin, Brashear.
Ladies and gentlemen, are you able to hear? I'm going to need you to make sure you keep your voice a little bit elevated so that the jurors can hear you. Okay?
Yes.
If we ask you to do that during the course of your testimony, we're not trying to be rude. We're just trying to make it so our jurors can understand. Okay?
Certainly, yes.
Ms. Brashier, Mast, you may inquire.
Thank you.
Can you tell me about yourself and who you brought with you today?
Yes, my name is Robin Brashier. I've been married to James for 43 years. I'm your mother and the mother of 8 other of your siblings. I am a registered nurse. I work voluntarily in the community with the Elsie Valley Resilience Coalition. And my companion here is Max, and she helps assist me with mobility because of some visual changes that I've had. So, and I also need to wear these glasses because I'm very light sensitive.
Would you like us to dim the lights a little for you? We're able to do that to make you more comfortable.
I'll be fine.
Okay.
I'll leave these on because they help to relieve spasms around my eyes. So.
Can you tell me how many grandchildren you have, roughly?
Thus far, I have 12 grandchildren.
Are you a Christian or faith-based individual?
I am a follower of Jesus in the first century patterns, not any specific denomination, but I'm also an ordained minister.
Can you describe how you raised me?
I raised you in a Christian home. You were homeschooled. I was a homemaker for 25 years before returning to school and obtaining my degree in nursing from LCSC.
What is your opinion of why this lawsuit happened?
Object to relevance.
I'm going to sustain it on relevance.
Okay. Can you describe how you originally felt about John Mast when I first started dating him?
I can. We were very involved with ministry with the upper leadership of the group that he was with. We were acquainted with his family, but we were closer to the 2 bishops because of the networking we were doing nationally for their community. So we had an acquaintance with John. He really seemed to be financially responsible, very sober, a little bit standoffish, but over time, as we got to know him and things progressed with both of you working together on the fire department. Ultimately, John was very much, we were very happy to have him as part of our family. There were some concerns we had because of a broken engagement that he had previously, which is very rare in his culture. And there were some negative rumors, but he didn't show himself. He didn't show himself to be anything to be concerned about, except for the fact that he could be somewhat arrogant and tended to challenge people inside of their field of expertise. And But other than that, when you married him, we were happy. And one of the happiest days of my life was when I was present with him at the birth of my oldest granddaughter. And he was loved and welcomed into our family. I did not see that reciprocity, unfortunately, with you. Our family is more eclectic. We welcome people from all different cultures. And that was not as easy for his family. That was generationally not as easy. But we thought with love and time that he would come to be at home because of friendships that developed inside of the family. And he was welcomed and loved, but we did not have a lot of time with him after we relocated to Idaho. You returned with Ashira, with my oldest granddaughter, when she was 6 months old, related to your fears about his pornography addiction. And we were unaware that that had been a
Your
problem.
Honor, I think this is getting way off track from what the original question was. I would object.
Can you state your objection more clearly in terms of?
Your Honor, I think it's turned into a narrative. I think she answered the question in the first few seconds, and now it's gone on to some kind of narrative.
I disagree.
I'm going to sustain the objection in the sense that the answer is not necessarily responsive to the question. That said, I'm going to ask you to ask another question at this time.
Okay.
Go ahead.
Can you describe when you first started having concerns about John Mast's behavior?
Actually, it was about when he came to get you a few weeks after that, after he had some time with us, and he had some time to think. We sat down with him, your dad and I, and challenged him to say he was at a crossroads. He could go one direction or he could go another. And he needed to choose, and he needed accountability, counseling. And we had really hoped that that had been the case. But when we came to Libby, Montana, after he had decided to move to Williston, when we arrived and we saw that he had significant cash in his pocket from the sale of his share of a business, you were in
Your Honor, this is nowhere near
ragged.
responsive.
Okay, I need you to stop speaking just for a second while I parse this out.
This is nowhere near responsive to the question that was asked.
I'm going to sustain that objection. I'm going to ask you to respond directly to your daughter's question. I'm
asked-
sorry, Ms. Brashier.
Okay.
I'm just going to ask you to respond to her question.
You were placed in a moldy, mouse-infested $1,000 RV.
I'm sorry, Ms.
That
Brashier.
was a problem.
Ms. Brashier, there's not a question pending. I'm going to instruct the jury to disregard. I'm going to strike that testimony because there was not a question pending. Ms. Brashier, I'm going to ask you to ask a question of your mother and she
Okay.
can respond to it.
Alright. Did John Mast agree to receive counseling for his sexual addiction issues? Are you aware of that?
Objection that calls for hearsay.
I'm going to sustain that objection.
Did you ever have concerns regarding John Mast drinking heavily?
Objection.
Yes.
Relevance.
I am going to overrule that. I know that we had testimony earlier about that, so I'm going to allow that question to stand. You may answer that question.
Yes, I did have concerns about him turning toward heavy drinking, hard liquor. He would drink Jack Daniels. He had a bottle on the top of the refrigerator, and he would
Your
come
Honor,
home and drink
objection.
it.
The question was, do you have concerns? That's yes or no.
Yes.
I'm going to sustain that objection. I'm going to ask the jury. I'm going to strike the remainder of that testimony, ask the jury to disregard that. Ms. Brashier, Master, may I ask another question?
Did Ashara ever seem afraid of John Mast?
Objection.
Yes.
Leading.
I'm going to overrule that objection. I think that that's a yes or no question, so I'll let that question stand. You may answer that question.
Yes.
What did you witness that made you think she was afraid of John Mast?
The first night that she was in our home, she asked us to tape a sheet around the windows because Daddy could sneak in at night.
Hearsay.
I'm going to sustain that objection. I'm going to instruct the jury to disregard that testimony. I'm going to strike the last part of that testimony.
Did you witness John Mast? Did you witness anything else that made you think she was afraid of John Mast?
Nightmares, night terrors, yes. Yes.
Did you witness anything else that made you think she was afraid of John Mast?
Yes, she told us why.
Objection, and I would ask that that be stricken.
All right. I'm going to sustain that objection. I think that's hearsay, and I'm going to require that it be stricken. The jury's not to consider that.
Did Shira ever come to you and show any physical evidence of being afraid?
Yes.
How so?
Crying, shaking, sleep disruptances. She was very hypervigilant, very easily afraid of everything.
What did you witness that made you think, did you witness Zane Mast being afraid of John Mast?
Yes.
How did he express fear?
He came out and he told us,
Objection.
Sustained.
Hearsay.
Sustained.
Again, how did he express fear?
disrupted sleep, bedwetting, long after the age with that he was potty trained.
Did Shire also have issues
Yes.
with bedwetting?
Yes.
Did that ever subside?
Yes, after they were safe.
Around what time did that stop?
Objection to relevance. I don't know how that's relevant.
I'll move away from that question.
I'll sustain that objection and allow you to move on.
What was Zane's behavior like when he first came to your home in December 2017?
He punched Ashira and you frequently.
And what did he do that because he was emulating anything?
Objection calls for speculation.
Sustained.
What was Ashira's behavior like when she first came to your home in December 2017?
Timid and hiding.
What is Zane's behavior like now?
Objection to relevance.
I'll sustain that objection.
Did you participate in an interstate compact which cleared me as a safe parent?
Objection. It's
Yes.
referring to some kind of document that is hearsay and facts that are not in evidence.
Danielle Hendricks was allowed to.
Well, stop for a second. I'm gonna overrule that objection. The question was, did you participate in a process? I'm gonna allow that question to stand. I heard the answer to be yes.
Can you describe what an interstate compact is?
Objection to relevance and lacks foundation.
I am going to sustain that objection at this time.
What did you have to do to be a part of that interstate compact?
Background checks and home inspection.
Was it difficult to obtain that interstate compact?
Yes.
Objection to relevance. I just don't know what it has to do with this case, Judge.
I'm going to overrule that objection at this point. I think she's talking about a background. I'm going to allow that question to stand. You may ask your next question.
Okay. To your knowledge, was John Mast considered as a possible safe placement?
No.
Did Sergeant Daniel Hendricks say something to the effect that the children are safe with you in Idaho, that I rescued 30-something children this week, and that was a priority to investigate, or something to that effect?
Yes.
to you?
Objection, hearsay.
I am, review with me the question that you just asked again.
Did Sergeant Daniel Hendricks say something to the effect of the children are safe with you in Idaho, that I rescued 30-something children this week, and that was a priority to investigate, or something to that effect to you?
Meaning to?
To
Okay.
her.
To me.
I'm going to allow that question. I think that's potential impeachment. The question was asked of Sergeant Hendricks yesterday, so I am going to allow that question to be answered.
Yes.
Following this statement, did you trust, and I would ask that Daniel Hendricks have impeachment over that answer.
Go ahead and ask your next question.
Following this statement, did you trust Sergeant Daniel Hendricks to perform a thorough investigation?
No.
What is your personal relationship with Ashira Mast?
Very close.
Do you help Ashira with her math weekly?
Objection,
As
relevant.
the tutor.
I am going to sustain that.
Okay.
I'm going to allow that first question to stand, but I am going to sustain the objection to this one with regard to the last question you asked.
What other things do you do with Ashira?
Objection, relevance.
It goes to her being involved personally with Ashira.
And is that question related to current or is it related to
It is
current?
related to current.
Okay, I'm going to sustain that objection. I don't know the relevance today,
Okay.
considering facts from a while ago.
Betty Mast described a blue Suburban which she repeatedly saw. What color was the Suburban?
Gray and maroon.
Objection to the form of the question, and I'm not sure. Betty Mast?
Betty Troyer.
Okay, let me sustain the objection. I'm going to ask you to re-ask the question.
What color was the Suburban?
Gray and maroon.
Stephen Mast also described a blue Suburban. What color was the Suburban?
I'm
Gray
going
and
to
maroon.
object, Your Honor. I think she's referring to witness testimony that this witness was sequestered from. I don't think
Oh,
that's
I
appropriate.
apologize.
I think that, and if that's the case, I'm going to sustain the objection.
Okay. What color was the Suburban?
Gray and maroon.
Is this the same Suburban I sometimes drove to visitations?
Yes.
Did I also drive with you in your white vehicle?
Yes.
Were you also aware that my sister Elizabeth Cook drove with me sometimes as well?
Yes.
Did I also take transit services?
Yes.
Where did we park during the visits?
Close in proximity.
What was your conversation about Ashlyn Weza's credentials?
Object to the form of the question and need some foundation.
I'm going to sustain that objection.
What do you believe your husband meant by the text or call, something to the effect of, "It's done"?
Objection, speculation.
Sustained.
Have I ever been a violent person?
No.
Do you believe me capable of killing anyone?
No.
Do you believe me capable of participating in a plan to kill John Mast?
No. Never
Why
hurt
not?
a fly.
Did you ever hear me make threats towards or about John Mast?
Never.
Are you around me a lot?
Yes.
Describe about how often over the years.
Since 2017, sometimes daily, multiple times a week.
And before that?
Frequent visits.
And I grew up with you, correct?
Oh, absolutely. Yes. Yes.
Do you believe you would have known if I was planning to kill John Mast?
Yes.
Would you have reported a plan to kill John Mast?
Yes.
Why would you have reported this?
Because I can't hurt people.
How has the killing of John Mast affected you personally?
Objection, relevance.
Sustained.
Has the killing of John Mast affected other family members as well?
Yes.
Would you have avoided this hardship with a phone call to law enforcement if you could have?
Yes.
Do you believe I would have avoided you suffering this hardship with a phone call if I had known?
Yes.
No further questions.
Thank you. Mr. Hickey, you may inquire.
Thank you, Your Honor. Ms. Brashier, I only have a couple of questions for you. Can you hear me okay?
Yes.
Do you recall giving your deposition in this case?
Yes.
And that's sworn testimony that you did, right?
Yes. I do have to say sometimes memory is in the moment.
But you do remember that?
Yes.
And you didn't seem to have any memory problems just a few minutes ago, correct?
Yes.
And you remember Mr. Miller asked you questions and you gave answers under oath.
Yes.
I want to ask you about one section of your deposition. You're aware that your husband was with Rebecca all day on February 5th, correct?
Yes.
And there were at least two or three times that they talked with you, correct?
Yes.
And do you remember at 5:30 p.m. having a phone conversation with your husband about this Plan B?
I remember a phone call in which I was hearing children crying and screaming.
I'm not asking you about that.
That happened at about that time. So I don't remember specifics. That was very traumatic to hear that.
Okay. I'm talking about a phone call in the car with your husband, and Rebecca was in the car as well, and you talked about Plan B. Do you remember that?
I can't remember any details about that except the crying and screaming. I still have nightmares about that.
Okay, so you don't remember that phone call with your husband, correct?
I remember it happened. I remember the children crying and screaming.
Yeah, you said that
but
3
I
times.
don't-
I'm asking you about the rest of the phone
But I
call.
don't remember the content of the phone call.
Do you remember about a Plan B being discussed? Does that phrase
There
mean
was
anything to
no
you?
memory of discussion. I was hearing I was hearing, and my heart was breaking.
Okay. And you knew that Rebecca was going to have to take the children to the visitation at 6 o'clock, correct?
Yes.
Do you remember in your deposition talking about that James, your husband, was with Rebecca all of that day because he really wasn't going to separate from her with all of that going on? Do you remember that?
That sounds like that would be the case.
Did you have concerns as well about Rebecca going and doing a visitation exchange with John Mast?
Oh, yes, yes,
And you wanted your husband with her as well, correct?
yes.
In fact, in your deposition, this is on page 66, these are your words. He was not going to have her drop her children off to go to an abusive visit and leave her by herself. Common sense would say that if, regardless of how all of this was going to play out, you were talking about the protective orders and all that stuff, James was not going to separate from Rebecca.
Correct.
Because he wanted to be with her to go meet this monstrous abuser, correct?
Yes.
Because he's devoted to her.
Yes.
He's going
But
to
if she doesn't want him there, he would get out of the way.
I don't know what you mean by that, but here's my point. He did leave her, didn't he?
Because she was busy with her children and
You weren't there.
distraction.
You weren't there. You don't know what she was doing. You were 30 miles an hour, 30 miles away in Lopway,
Her
correct?
children.
You were 30 miles away in Lopway, correct? Yes or no?
Yes, of course I was. That was my place of employment.
He did leave her. And he was going to let her go to that visitation exchange by herself. And he did that because he knew she was never going to meet John Mast. Isn't that correct?
No.
Because
That's
she
not
knew
correct.
and he knew he was going to go kill him.
No, that is not correct. He was overwhelming in his needs, and she needed to take care of her
That's all I
children.
got.
Thank you. Mr. Brashier, any cross-examination? Any
No,
cross?
sir.
All right. Ms. Brashier Mast, any redirect?
Yes, yes, Your Honor. How devoted am I to my children?
Completely.
In that moment, would I have cared about what he had going on?
No, not in that case.
If I knew I was gonna lose my children, would I focus primarily on that?
Only on them.
Would I put his needs over my children?
No,
Would I put anyone's needs over my children?
no,
Would I risk custody of my kids over my dad?
no.
No further questions.
Mr. Hickey, any recross on that?
Just briefly, Judge. In your deposition, do you remember saying that if there was some kind of a plan for a shooting, and you were talking about your husband and Rebecca, it's unlikely that either of them would have liked to have had a law enforcement person right there on site. Do you remember saying that?
Yes,
That if they had a plan to shoot somebody, they wouldn't want law enforcement right there, right?
which they requested.
But your husband refused it. You're talking about the safe exchange?
Yeah, she didn't.
Okay. But there wasn't a law enforcement officer there.
They were close.
They didn't have a safe exchange around.
They were close.
Because they knew there'd be law enforcement on site. Isn't that right?
They
That's all
were
I'm
close.
Mr. Brashier, any recross on that?
No, Your Honor.
Okay, thank you. Ms. Brashier, you may step down. All right. While she's stepping down, we are at the noon hour. We're going to go ahead and take our noon break. We'll come back at 1 o'clock and get started. Ladies and gentlemen, members of the jury, I remind you that you're not to discuss this case among yourself or with anyone else, nor to form any opinion as to the merits of the case until after I finally submit the case to you. We'll reconvene. We'll start back up at 1 o'clock. Ms. Brashier Mast, if you can have our next witness ready, get right into it. All right, please rise for the jury.
Is it on?
All right.
They will let you in the meeting. So just wait. They will let you in the meeting, just please wait. I have to let you go now.
Okay, let's go on the record. We're back in session in Nez Perce County case CV 35-23-195, Mast v. Brashier. We are outside the presence of the jury. Mr. Brashier, Ms. Brashier, Mast, the defendants are present at the defense table. The plaintiffs and their attorneys are all present at plaintiff's table. Counsel parties, are there anything that we need to take up? It sounds to me like I see Elizabeth Cook in the waiting room. I presume that's your next witness.
Yes, Your Honor.
Okay. And as we articulated earlier, there was a motion made for her to appear by Zoom. There was no objection to that. Court's going to allow that. Anything we need to take up before we bring the jury back in?
Not at this time, Judge, thank you.
No, you're on.
Okay, please rise for the jury. Thank you. You may be seated. All right, ladies and gentlemen, welcome back. The record will reflect the jury has been returned. They appear to me to be properly seated. Will the parties stipulate that the jury is back and properly seated?
Plaintiff stipulate.
Yes, Your Honor.
Yes, Your Honor.
Thank you. All right. Ladies and gentlemen, when we left off at the noon hour, Ms. Brashier Mast was presenting her case. And Ms. Brashier Mast, you may call your next witness.
I call Elizabeth Cook.
Okay. And Ms. Cook is present by Zoom. And what I might have you do, if it's easier, I might have you just stay at that.
Just stay over here.
And the reason I'm saying that is I suspect that microphone will pick up you much better right there. So I'll allow you to question, and then whomever is doing the cross-examination, I'm just going to have you stay at the table as well, closer to the microphone. All right, Miss Elizabeth Cook, are you present?
Yes.
All right, are you able to hear me?
Yes.
All right, I am going to turn your attention to my clerk, who is going to place you under oath. If you can raise your right hand.
Do you affirm under the penalty of perjury that the testimony you will give in this matter shall be the truth, the whole truth, and nothing but the truth?
I do.
All right, thank you very much. All right, give me just one moment. Okay, Ms. Brashier Mast, you may inquire.
Elizabeth, who are you to me?
I'm your sister.
How long have you lived in Lewiston, Idaho?
Around 12 years, maybe longer.
What is the extent of your education?
I have a bachelor's degree in elementary education, well, it's interdisciplinary studies of education with a minor in math, and then I'm currently enrolled in a master's program for early childhood development.
What do you do for a living?
I'm self-employed as a behavioral intervention specialist. I work with kids with special needs on their behaviors.
Are you the aunt of Shira Mast?
Yes.
Are you the aunt of Zane Mast?
Yes.
Do you have personal knowledge of John Mast living in Williston, North Dakota?
Living in?
12 to 2017.
Yeah, I'm pretty sure he lived there.
Did you see, were you familiar with him around that time? Did you visit out there?
In what time frame?
From 2012 to 2017.
I visited maybe once or twice.
Did you ever have any concerns about John Mast's behavior towards Shira Mast from 2012 to 2017?
Once.
Can you describe that?
There was a time frame that I was out there because my other niece was born, and she was little, and there was an incident that happened in the living room, and I don't exactly remember what exactly happened, what started it, but Ashara was having some type of a meltdown, and he had taken her into the room and spanked her, and kept her in there for a very long period of time and brought her out, and she was very quiet after.
Did you ever have concerns about John Mast's behavior towards Zane Mast?
Yes.
What were those concerns?
There was one time we were up in Winchester, and I had found out afterwards that he had given him alcohol.
Did you ever have concerns regarding domestic violence in our home?
Objection, relevant.
Yes.
There's an objection, Ms. Cook. I'm going to ask you to hold off. Objection is relevance.
Yes.
Would you like to respond?
It goes to the behavior that was witnessed in the home. She has personal knowledge of that.
I'm going to sustain the objection right now. I don't have a lot of information on that. I'm going to allow you to ask some additional foundational
Okay.
questions, though.
What did you witness in our home from 2012 to 2017?
In Winchester or in Idaho or in North Dakota?
In Winchester when we visited.
I had heard of an incident where he had given Zane alcohol.
I'm going to sustain that objection.
Did Ashira ever exhibit fear of her father around you?
Yes.
What did that fear look like?
She had stated multiple times that she was scared of him.
I'm going to sustain that objection on hearsay.
Can you describe how that made her describe what that looked like in the sense of how she exhibited those symptoms to you?
Ashara would often make sure that the door was locked, windows were locked. She would look behind her often, and demonstrated a lot of signs of anxiety.
Did those symptoms disappear at any point or get better?
I believe they've improved recently, yes.
Did you ever witness that same fear in John Mast?
Yes.
Did that get better at some point with Zane as well?
Oh, yeah. Within the last few years.
Did I ever ride with you to visitations?
Visitations? I don't remember that now.
This sign of a happy, healthy herd. It also makes them.
Did your father have a concealed carry permit?
Yes, as far back as I can remember.
Did he always keep a pistol on him or near him or generally keep a pistol on him?
As far back as I can remember.
Would it appear out of character for him to not have a pistol on him?
Absolutely not.
No, would it appear out of character for him to not have a pistol on him?
It would appear out of character if he didn't have his pistol with him.
Did I ever make threats about John Mast?
No.
Did I ever threaten to kill John Mast?
Not to me.
Did you believe me capable of planning to kill John Mast?
No.
How has this affected our whole family?
Objection, relevance.
Sustained.
How has this affected you and your children?
Objection, relevance.
Sustained.
Do you believe I would have made a phone call to law enforcement had I known what James Brashier Sr. was going to do?
Objection, calls for speculation.
Sustained.
No further questions.
Mr. Hickey or Mr. Miller, cross-examination?
No, Your Honor, thank you.
All right. Mr. Brashier, any cross-examination?
I'm sorry.
Any cross-examination?
Oh, no, sir.
All right, thank you. May this witness be excused?
Yes, Your Honor.
All right. Ms. Cook, thank you for your time today. We'll excuse you. Appreciate your being here.
Thank you.
Ms. Brashier Mast, you may call your next witness.
I have no other witnesses.
All right. So are you resting your case at this
I
point?
am, Your Honor.
All right. Thank you. Mr. Hickey, Mr. Miller, any rebuttal witnesses that you'd like to call?
Can we have 1 second on
You
the
may.
agenda? Or-
Yeah. For the sake of convenience, can we step out for just a moment?
You may.
Thank you.
Let's do this, ladies and gentlemen. We're just going to Mr. Miller, how much time do you think you need? A couple minutes?
5 minutes.
Okay, why don't we do this? Why don't we, I'm gonna,
Less, Judge, not long.
I'm gonna send them back. I'm gonna give you some time to discuss that.
Okay.
I'll send them back and we should be with you promptly. Ladies and gentlemen, I remind you that you're not to discuss the case among yourselves or with anyone else, nor to form any opinion as to the merits of the case until after I finally submit the case to you. We'll be right back with you. Please to rise for the jury. Okay, you may be seated and let's take a minute and be back on the record when they're ready. Thank you. Please be seated. Let's go back on the record. We are back in session in Mast v. Brashier. Nez Perce County case CV 35-23-195. We are outside the presence of the jury. Mr. Brashier, Ms. Brashier, Mast, defendants are present at defense table. Plaintiffs and their counsel are present at plaintiff's table. And we just took a brief recess, Mr. Miller, to give you some time to consider whether you wanted to call any rebuttal witnesses.
That's exactly right, Judge. That's what we did. We have no rebuttal.
Okay. All right. Let's do this then. We need then to talk about jury instructions. We're at 1 o'clock. I hate to lose this afternoon.
Right.
How much time do we need before we are prepared to talk about instructions? I think when it comes time to providing instructions, we need to be aware that I suspect, given what I think the length of them are, it's going to take us half hour, probably 40 minutes to instruct the jury.
Yeah.
What's your thought? Do you, an hour, is that sufficient?
You know, I was hoping for a little bit more, Judge. I wonder, and I certainly want to be mindful of the jury's time here. I wonder if we could come back at 3. Is that too long?
I'm completely comfortable with that. 3 o'clock. Or
can...
even, yeah, I think 3 would be just fine. That would give us about an hour and 40 minutes for us to kind of work through that. We had our informal conference, informal yet semi-formal. It was on the record earlier this morning, but I want to make sure everybody's had time to consider those. And
you know, Judge,
the other thing, and I recognize I don't want to lose
the day,
today.
Right.
That said, I think with closing arguments, I don't know how long that's going to take. I'm not going to put a time limit on anybody's closing argument, but again, I'm warming up to the idea, do we come back and just be ready to go, start at 8:30 with instructions and get them deliberating?
Oh.
I'm open to suggestions.
Oh. I had one thought. That's right. We're just talking about, what would happen at 3 o'clock, and 3 o'clock we would come back and talk about jury instructions, get those settled. I also, as I mentioned earlier this morning, I would like to bring a motion to reconsider, and I'll have some argument on that. That'll take some time. And I don't know if the court wants then overnight to consider the argument.
Maybe. I think I'm hearing that it might be better if we excuse the jury today. The other thing I'm thinking is I need to prepare copies of the jury instructions that we settle on for the jury. I'm required to send at least the original and 2 copies in there. My practice is to provide a complete copy to all the jurors. I find that when they have something to follow along with, it's easier than just listening to me talk for what could be probably a half hour.
Right.
And I know that takes some time. How about this? Why don't we plan to get together at 3:30? That's 2 hours.
Mm-hmm.
Then we can work through jury instructions. I don't think that was going to give us enough time to make your motion that you want to make. I don't think that's going to give us enough time to get them copied, get them to the jury, and then let's bring them back and be prepared to instruct and then argue so they can start their deliberations tomorrow morning. I'd like to, if we do that, I'd like to be reading jury instructions to the jury by 8:30. Would that work for you?
I think just one moment.
Okay.
Yeah, Judge, if we could do that, appreciate that. Thank you.
And that gives you some time to, Ms. Brashier, Mast, and Mr. Brashier, I want to give you time to digest some of those jury instructions that we talked about this morning. Let's do this then. I'll plan to meet with counsel. We can meet in this courtroom at 3:30. We can continue our discussion with jury instructions. We can take however long we need. We don't have to worry about a jury, and I'm going to bring them in, let them know we're here. Rather than have them just wait for us, we're going to come back and we'll be in a position to do instructions and closing arguments tomorrow morning at 8:30.
Oh. That's probably true. Yeah, that's a good point, Judge. If we're going to hold off till the morning, we probably could come back in, say, an hour to do arguments on jury instructions.
Do you want to do that? I'm happy to do that.
We could do that, an argument on jury instructions and then argument on motion reconsider. We could take all, because I'm ready to go on that. So, but we need some time to talk about the jury instructions.
Okay.
And so, yeah, maybe just an hour.
Well, let me ask you this. How, and I'm not putting words in your mouth, but how close are we on jury instructions to your liking from what we talked about today?
There's 4 or 5 we need to take a look at and check. We didn't get a chance yet to look in depth at the verdict form and see how the algorithm follows, and I want to take a look at
I
that.
think we feel most of them are okay.
I think so, yeah.
Well, and again, again, I want to be clear, the jury form is just, that's me. If there's a better way to do it, I don't know how you've done it in Ada County or the other counties. I'm happy to be educated.
Sure.
It wasn't provided to me by any of the parties or counsel, so this was just my stab at it. So I'm not married to the idea of doing it like that. But
yeah.
Let's come back in an hour. In any event, shall we just excuse the jury until tomorrow morning?
Thank you, Judge.
Mrs. Brashier, Mast, is that fine?
That's fine with me.
Mr. Brashier, any objections? Okay, let's bring, please rise. Okay, please be seated. Record will reflect that the jury is back. They appear to me to be properly seated. Will the parties stipulate the jury has been returned and are appropriately seated?
Yes, Ron.
Yes, Your Honor.
Yes, Your Honor.
So ladies and gentlemen of the jury, let me tell you where we are at in this process. We are done with the evidentiary portion of the trial. What happens now is I need to get together with the attorneys and with the parties. Based on the evidence that has been produced, that is going to determine the instructions that I am going to give to you. We need some time to work that out. And I wish I could tell you it was going to be 15 minutes. It's not going to be. So the upshot is we are going to break for the day because I don't want to keep you here for 2 hours, 2.5 hours waiting for us because I think what I can do is meet with the attorneys and the parties. We can get this squared away. We will reconvene tomorrow at 8:30. When we get back together tomorrow at 8:30, what will happen is I will have the instructions prepared. I plan to have copies for you of those instructions. I will give those instructions, and then I'm going to allow the parties to make their closing arguments, after which time we will send you for deliberations. Now, the other thing I want to note is if you've been keeping count, there are 13 of you. So a jury consists of 12 people, so there is going to be an alternate. And one of the reasons we have an alternate is because in a multi-day trial like this, I just don't know what's going to happen. So what will happen is after I provide the instructions tomorrow, after the parties make their closing arguments, one of you at random is going to be the alternate. I'm going to excuse you with the instructions to stay close to your phone just in case something happens. And then the remaining 12 will deliberate. And I do that because I've been in situations where we haven't done that. All of a sudden, we're down the required number of jurors, and we've had to start over. So that's the reason that I always have an alternate on a multi-day trial. So I don't want there to be any surprises, but whoever is going to be the alternate does need to be present for the closing arguments and for the reading of the jury instructions, because if something happens, what would happen is the alternate would come back in, and then you would essentially restart your deliberations with the alternate. So it's a minor inconvenience for whomever is chosen to be the alternate, but at the end of the day, it could save us from having to repeat this whole process over. So I want to be transparent about what will happen tomorrow. So with that, again, I thank you for your patience. I thank you for your attentiveness. I'm going to maybe share with you one last time. Members of the jury, I remind you that you're not to discuss this case among yourselves or with anyone else, nor to form any opinion as to the merits of the case until after I finally submit the case to you. Again, with that, we're going to excuse you for the evening. We'll see you back at 8:30. And again, when we reconvene tomorrow morning at 8:30, what will happen is I will give you instructions, you'll hear closing arguments, and then you will go directly into deliberations at that time. Okay? All right, please rise for the jury. Okay, you may be seated. Did we decide 2:30? Mr. Miller, Mr. Hickey, did we decide 2:30?
Yes, Your Honor.
Okay, I'll see you in an hour. Okay. We get from the chief every month or so, it's all the dirt from judges who get themselves in trouble. And I remember, oh, it was like maybe a year and a half ago, I saw that and I thought, okay,
Don't want to be on the dirt page.
that's interesting. That's interesting. So. All right, let's go ahead and we can be on the record. We are back on the record in Mast v. Brashier, CV 35-23-195. Mr. Brashier, Ms. Brashier, Mast defendants are at defense counsel table. The plaintiffs and their attorneys are present at counsel table. We are outside the presence of the jury. This is just our opportunity to continue our discussion as to jury instructions. And so maybe what I'll do, Mr. Miller, let me. Oh, yes. Would you make sure your mic, yeah, there we go. And then I think, Mr. Miller, yours is it covered or uncovered?
It's on, it's not.
Oh, now, there we go. All right. I just want to make sure the record is picking that up. All right, so Mr. Miller, why don't I just start with you? Let's, again, as I indicated, 1 through 6 have already been given.
Yeah.
I'll just start maybe with the easy ones. Is there any objection to instruction 7 as has been proposed by the court? That's a standard one I give even in my criminal jury instructions. It basically just says you've heard the evidence. I'm going to instruct you as to the law. You have to follow the rules as I explain them to you. You can't follow some and ignore others. Any objection to 7?
No objection.
Mr. Brashier, Ms. Brashier, Mast, any objection to that?
No objection.
Okay, that was easy.
And I can go a little faster, Judge. No, we have no objection to 8.
Ms. Brashier, Master, Mr. Brashier, any objection to that?
No, Your Honor.
So 8 is okay.
No objection to 9.
No, Your Honor.
No, Your Honor.
Okay, number 9 is okay, so no objections to that.
No objections to 10 or 11.
No objections as well.
Okay, 10 and 11 are good with you, Miss, as well? Okay.
No objections.
12 and 13, Your Honor, as we get to these, and they're in my packet, they're facing each other, which is kind of handy. Because this is the first point we get to where we've got an issue from our standpoint.
Okay.
It looks to me like we don't need 12 and 13, that they're duplicative, but also not exactly. We ought to pick one or the other and maybe combine them, is what I'm thinking. And I would prefer to use number 13 because that's the statute. Right out of Idaho Code 5311. The difference is, and I know that I actually proposed both of these, it looks like,
Okay.
so that's my bad. Coming from a criminal defense background, I'm used to having elements listed in.
You're speaking my language.
So I went looking for elements, right? And I found that case, but the elements don't match exactly what the statute says. So the elements say an actionable wrong committed by the defendant against the decedent, and that same actionable wrong caused the decedent's death. Whereas in the statute, it says when the death of a person is caused by the wrongful act or neglect. And from our standpoint, it's important based on the evidence that's come in that we have wrongful act or neglect involved in the definition here. And as we go through the rest of the instructions. So if we want to say, if the death of John Mast was caused by the wrongful act or neglect of defendant James Brashier and or defendant Rebecca Brashier Mast, then his or her heirs, blah, blah, blah. We could do it like that. We maybe could leave 13 alone. Just go with that.
Ms. Brashier, Mast, you had a comment on that?
To be clear, I was under the understanding it was not heirs, it was only Robert Mast.
Well,
Robert Mast is an heir.
he is an heir under.
Yes, just to
right.
be clear, it's not Betty and Steve.
No,
Correct.
That's true, it is, yeah.
Yes.
Right, and so here's how I viewed 12 and 13. I viewed 12 as this is what must be shown, and I think that's pretty clear from the case law. I viewed number 13, your proposed number 13, to essentially establish or to instruct that Robert Mast is an heir. that's how I viewed the two of them, how the interplay happened. So I'm happy to keep both of them in.
Okay.
In looking at, I think Ms. Brashier Mast raises an important point. And I don't know if you added that sentence, under Idaho law, a parent is an heir and able to maintain an action. If there's some confusion, we could put under Idaho law, Robert Mast is a parent and an heir able to maintain, so we could specify that it's his cause of action as opposed to anybody else. Again, I want to be clear, I agree with Rebecca Brashier Mast that the other siblings are not entitled to claim, well, under the facts under the evidence as presented,
Right.
I can't find that they would be entitled to an instruction as well. So I'm happy to leave it as is. I'm happy to clarify that.
No, we agree with
Mr.
that,
Hickey I didn't know if he had a thought on that. It looked like he might have.
We're in agreement, I think.
Yeah, we are. We're in agreement.
We're okay with that, Your Honor, and certainly I understand the distinguishing, one of the distinguishing criteria here between these two is the definition of error. Fine with that. Fine that with the idea that Robert is the only heir here. My point that is important to me or to our side, I think, is that in 13 it says wrongful act or neglect, whereas in 12 it doesn't mention neglect. And I want to be able to argue the or neglect part of the. So if actionable wrong is defined as a wrongful act or neglect, then I'm okay with that.
I think it would be. That would be my opinion, because you have causes of action for neglect, which, for example, negligent infliction of emotional distress, which is an actionable wrong, and that implies neglect. So I'm viewing it the same way.
Okay, great. Then we're okay with both of those. Then as
okay. Before we leave 12 and we leave the claims for wrongful death, in my, I'm going to call it my algorithm.
Yes.
Because I don't have any better way to describe it. I think what I have done is we were talking about a collateral estoppel, a claim preclusion, and I had one blank for wrongful death. I think upon reconsideration, my inclination is to ask the questions as to Rebecca Brashier with a blank for damages, and then ask the question as to Robert Brashier, because it's important to me, I think, to clarify that even though I believe that this claim preclusion applies to Robert Brashier, I do not think it applies to Rebecca Brashier. So I want to make sure that we're clarifying that she wasn't in any way, shape, or form convicted, and so I don't want to impute any. I don't want to say liability may be the right word or maybe the wrong word on her for her father's conviction. Does that make sense?
Yes, we agree.
That was my next question, Your Honor.
So what I'll do then, that's going to change the algorithm. So we're going to have to keep our eye on the ball, but I intend then, what I'll do is I'll ask the questions as to her and then what damages, and I think we can craft something in the verdict form that specifies these are damages as to her, and then we'll have another line specify those are damages as to Robert Brashier. And
when we get there, I've got.
Yes, that was just a note I had there. Mr. Brashier, you had a question.
You continue to call me Robert Brashier, and for the record,
I apologize. I apologize, Mr. James Brashier. So
yes, Robert's my middle name.
all right. I'm glad I wasn't calling you anything bad then. So, again, thank you for that. I mean no slight.
None taken.
Okay, appreciate that. All right, so that's 12. Let's as we look at 12 and 13 again, I think 12 is an accurate statement of the law. 13, as I reviewed, Idaho Code 5-311 is an accurate statement of the statute. Mr. Brashier, Ms. Brashier, Mast, any objections to 12 and 13, which are just the elements and definition?
No, Your Honor.
Okay, so 12 and 13 are okay. Okay, so that takes us to instruction 14.
On 14, Your Honor, we talked earlier this morning about just, of course, removing that bottom portion about collateral estoppel. But beyond that, the upper portion, that's the actual instruction, The only correction I was going to proffer is, if we look at the paragraph that starts therefore for purposes of this case, second line, committed and says actionable wrong. I was going to change that to wrongful act based on what I just argued a minute ago, but also because it says wrongful act later in the same sentence. So it would just make it consistent.
Okay, which way do you want it to read? I'm okay with either one.
Wrongful act.
Wrongful act.
May I ask why we're taking out the
portion underneath? Okay, those were just my notes, and so that wouldn't be part of the instruction. While we're on that issue, and let me tell you why I think collateral estoppel applies, and I want to make a record of this as well, as to why I would allow this jury instruction in. Under Anderson versus City of Pocatello, that's 112 Idaho 176. That appears to be the primary case in the state of Idaho with regard to claim preclusion. The question is whether or not Mr. Brashier had a full and fair opportunity to litigate his liability for the death of John Mast. And I put on the bottom of that jury instruction, just for your reference, just so we could have this conversation, the elements that were proven beyond a reasonable doubt at the criminal trial of Mr. James Brashier. So the elements of voluntary manslaughter that relate to the wrongful death are that the defendant engaged in conduct which caused the death of John Mast, and the defendant acted unlawfully. And again, the elements of wrongful death, as we've been talking about in our proposed instruction 12, are that the defendant committed an actionable wrong against John Mast, and that same actionable wrong caused John Mast's death. And so I think those elements match. The next issue is, so that was the first question, is whether or not we're talking about the same elements, and I think we are. The next question is whether liability for voluntary manslaughter was actually decided in the criminal case. It was. We had a jury return a verdict on voluntary manslaughter. The next question is, was there a final judgment on the merits? The answer is yes. That judgment was entered. I want to say it's Plaintiff's Exhibit 6 or 8. It's one of the exhibits that is the certified copy of the judgment of conviction. My clerk is telling me it's Exhibit 5, and I believe her.
We do too, Judge.
Yeah, that's you've got good sense. So there was a final judgment on the merits in that a final judgment was entered. And then the next, I think, the final issue is whether James Brashier, the party against whom the issue is asserted, was a party to the prior criminal proceeding. I find that he was. The judgment and conviction is to him. Again, as to whether or not he had a full and fair opportunity to litigate his liability for that death in that criminal case, I think the answer is yes. We had a full and complete jury trial. I note that Mr. Brashier, in that trial, testified on his own behalf. He provided a robust defense, and there's no question in my mind that it was he had a full and fair opportunity to litigate his liability. In fact, he received a more favorable verdict than I think the state wanted him to receive. So the state had originally charged him with first-degree murder. The jury acquitted on first-degree murder, they acquitted on second-degree murder, and they convicted on voluntary manslaughter. They were also given an opportunity to consider involuntary manslaughter. I think under the circumstances reviewing the involuntary manslaughter elements, had he been convicted of that, I still think that satisfies the elements. They are the same elements that we're talking about for purposes of a wrongful death. So had this come before me in the form of a summary judgment motion, I would have granted that, because I do think that claim preclusion here, I think it applies. So that's my justification for the record of why I would allow 14 in. That said, you didn't ask for 14. That was my idea. If you don't want the jury to be instructed on claim preclusion, I'll defer to you.
Oh, no,
I think we want it.
Okay. And then the only other I think addition that I may add to the bottom of 14 is just a sentence that says, this does not apply to Rebecca Brashier Mast. I want to be clear. I'm not sure how that will look,
Appreciate that.
but I'm assuming that that would be something that you would want in there.
I do
Okay.
appreciate that, Your Honor.
I don't know how I'll phrase it. I'll get a copy of that to you so that we can take a look at it, but,
Judge, you could do something in the first paragraph, the end of that first paragraph. You know, it says you're instructed that the defendant James Brashier in this case has been previously convicted of criminal proceeding. At the end of that, you could say something like, defendant Rebecca Brashier has not been convicted. I don't know if that's sufficient or not.
However Your Honor wants to draft that, where it differentiates between my father's conviction and the fact that I've not been convicted.
And you could even say, defendant Rebecca Brashier was not charged with nor convicted.
Okay.
Yes, that would be
Okay.
better.
Yeah.
Because I've had no charges brought against me.
Then we have the correction, or the change there in that towards the bottom, wrongful act instead of.
okay. Maybe what I'll do at the very bottom, I could say, defendant Rebecca Brashier was not charged with or convicted of any criminal acts relating to John Mast's death. Is that a fair statement?
Sounds excellent, Your Honor.
Any objection to that? No. I can either put it at the very end or I could put it right at the.
No, I'm not gonna say.
I'm okay with it.
You're okay with that? Okay. Where would you like that? I'll defer to you. Do you want it at the end of the first paragraph or at the very bottom?
I think at the very bottom would be good, Your
Very
Honor.
bottom it is. Okay. All right. But other than that, is there any other objection to 14? Any objection to 14 as we?
No, Your Honor.
Okay.
Judge, we have no objection to 15.
And I changed the spelling. Appreciate you catching my typos. And again, instruction 15, again, I wanted to just clarify that the Stephen and Betty are the two that have claims for negligent infliction of emotional distress, and that's as to James Brashier. Okay, and then these are the duties, and then what I would do is at the bottom part, anything with the case citations below, that's going to go away, but those case citations are simply for us to be aware of those. So any objection to 15 as proposed?
The only proposed addition we would have, Your Honor, is in that first line, the plaintiffs, Stephen Mast and Betty Troy, we would add Robert Mast to that list for intentional infliction of emotional distress.
Oh, okay. 15 is the negligent one. 16 will be the intentional one.
Correct.
All right. So 15 you're comfortable with?
Yes.
With as it reads right now?
Yes.
Okay. And we'll talk about the intentional here in a moment. Mr. Brashier, Ms. Brashier Mast, any objection to 15 as it reads?
No, not at all.
No, sir.
Okay. And then I'll correct the spelling of Mr. Brashier's name.
Yeah.
Okay, so 16. We have, actually,
Yeah, that's right. Your Honor, if we could go back briefly to 15.
please.
We would like to add Robert Mast to the list of plaintiffs on 15 and 16.
Okay, talk to me about.
The argument is basically, Your Honor, that that goes back to what I was saying earlier with 12 and 13 especially, where the statute allows for liability. Well, I think what it is, judges, is we feel like the evidence will show, or we can at least argue, that both defendants had a legal duty recognized by law to the plaintiffs, all three of the plaintiffs here.
Was that in your original complaint?
They had a legal duty to all three of the plaintiffs, and that duty was breached. Now, it was breached in different ways, of course. It was breached by different acts or negligence in either an overt act with the shooting, or an overt act by sending an email at a certain point, or simply a failure to warn. I think that we could argue, Judge, that that duty was owed and that duty was breached. So we'd like to add them to the instruction number, add Robert to instruction number 15.
Okay, so help me understand the evidence, I think, showed that when this happened, Robert Mast was several hundred miles away in Emmett.
True, but Your Honor, this infliction of emotional distress on the plaintiffs, right? Whether it was done negligently or intentionally, this emotional distress through the loss of their son was going to affect all three of them. Now, again, it's going to affect them in different ways. Stephen and Betty would have different effects, perhaps, because they were there to witness it personally. But Robert Mast certainly felt the effects of emotional distress as a result of the loss of his son, whether that loss was caused through negligence on the part of the defendants or intentional acts, Judge. I think either way, Robert Mast has testified, of course, that he's suffered severe emotional distress due to the loss.
Your Honor, may I?
Please, I'm happy to hear anything you've got to say.
At the risk of Mr. Miller throwing something at me because he didn't know what I was about to say. I think it comes down to a proximity issue. As I'm looking at this, I think Mr. Mast testified to physical manifestations and emotional. So I think we got over that hurdle. But if negligent, because it does mention that physical component that you have to have, and I don't know what the Idaho case law says, but if it has some kind of proximity, like you had to be there, you had to witness that kind of thing, he was several hundred miles away. We have to concede that. But if there's no proximity requirement, then I think he does qualify.
I heard clear testimony of physical manifestation of the injury. I guess where I may be hanging is maybe element one, the legal duty. As an example, I think as to Betty and Stephen, they were there present when the shooting actually took place, according to the evidence.
Totally understand
and
that. And you're thinking they're seeing all this happen right in front of them.
When there may be a duty of safety, there may be a duty of care, those kinds of things. And so it's very easy to see how this applies to those two, the siblings. I'm struggling a little bit more with how this applies to father who was away.
But then he's notified and he's on the phone with his son who is it's almost like they are there audibly. They're hearing what's going on. So that's why I say, to me, it comes down to this proximity issue. And I don't know what Idaho law says, whether you've got to be there or you could be somewhere else and still have that effect on you.
I would also like to be added to intentional negligent infliction of emotional distress as well for my father against him as well, because I also was on the scene and I also suffered trauma from it.
Well, that would be a separate action. I mean, you could file a separate action against your father, and I think that's a discussion.
File a separate one?
Well, Robert Mast is listed as a plaintiff, so he is a proper party to this action. I guess what I'm distinguishing is you're not listed as a plaintiff anywhere here. At some point, you could have done a cross claim or a claim against your father for that. So I would say if you want to pursue your father on that, that would need to be in a separate
hearing,
separate action, separate lawsuit at this point. So, but I understand what you're saying.
All right.
But I think for purposes of instruction 15, because you haven't filed a complaint, I wouldn't permit that.
Judge, I understand your argument here. I guess I'll concede the point here that I'm kind of struggling with.
myself with toying with element number one there, negligent infliction. I agree with Mr. Hickey that Idaho does not have the proximity or zone of danger requirement that some states have. And it's simply physical manifestation is all that's required. But before you get to that point, of course, you got to meet criteria number one.
Right.
What's the legal duty recognized by law? You know what? I'm okay if we leave Robert Mast off of number.
Okay.
And we just leave Stephen and Betty.
All right. Mr. Hickey?
Oh, I'm fine with that.
Okay.
We asked to add Robert Mast to 60.
Okay. So 15, then we leave that as is. And so really 15 will apply. The negligent infliction of emotional distress would only apply to Stephen Mast and Betty Troyer. Ms. Brashier Mast or Mr. Brashier, any objection as to that as it?
No, but I am wondering how we're getting him onto number 16
Okay,
then.
we'll talk about that. So
Okay,
any
thank
problems
you.
with 15 as it is right now?
No, I do not.
Okay. All right. Okay, so 16. And that's the intentional infliction. And again, I added the names Stephen and Betty only because, like I said, I was trying the best I can to do this, and I added this before hearing all of the evidence. And so your position then, Mr. Miller, is that Robert Mast should be added on that count as well?
Correct. Judge, I think we do meet the criteria here.
Okay.
Robert Mast, again, we don't have the same criteria as under negligent. We don't have an element of a legal duty recognized by law. We simply have to show that the defendant's conduct, whether we're talking about Mr. Brashier or Ms. Brashier, the conduct was intentional or reckless. The conduct was extreme and outrageous. There was a causal connection between that wrongful conduct and the emotional distress, and emotional distress was severe. All I did, of course, was read that, obviously, but I think that my point is, Judge, I think we obviously meet the criteria here for all three.
And I agree that is different, and I want to be clear, you had proposed it with the plaintiffs have alleged, and that was, and I added the names.
Oh, okay.
That was me.
Gotcha.
So I recognize that wasn't you, and I think your proposed instruction was the plaintiffs have alleged, well, I can't remember if that was, I don't think there was a specification. I just know that when I put those two names in there, that was me putting them in there, that wasn't any of the parties. Okay. I am agreeable to that because I do think the evidence does support, what I heard at trial would support this. We could do it one of two ways. We could just say the plaintiffs, plural, and leave it at that, have alleged separate claims of intentional infliction of emotional distress against both the defendant James Brashier and the defendant Rebecca Brashier Mast, and then go through, or we could identify all three by name.
Your Honor, quick question about this. Does this, when it goes down, the defendant's conduct was intentional or reckless, is that clear enough that it's dividing me and my dad?
Well, I think it is in this one simply because, keep in mind, they're alleging it as to you and your father.
Okay.
So this is one that they're saying you did it and he did it. And so rather than have an instruction for each of you, I combine them.
Okay.
And the reason that I'm more comfortable with that is because, again, it's a cause of action against both of you, and it applies that they're going to have to find these steps as to each of you. And as you go through the verdict form, and we'll talk about that here in a minute, it's going to step through questions as to each of these for both of you. Does that make sense?
Yes.
Mr. Miller, did you have an opinion on how you wanted maybe the first sentence of that 16 to look?
Yeah, we'd like to list each one of them.
Okay.
Thank you.
Okay, so I will just say the plaintiffs, Robert Mast, Stephen Mast, and Betty Troyer have alleged separate claims of intentional infliction against both the defendant James Brashier and the defendant Rebecca Brashier Mast, and move that. Any?
Is it motion or emotional?
Oh, it's emotional.
Did I misspell something?
Just emotional.
Yes. Okay. You're catching my fat fingers on my keyboard is what you're doing. So I told you I was working over the weekend on this. So. All right. So I appreciate you. And if there are any typos, please let me know. speak now, I guess, or forever hold your peace, so. All right. Any, other than that, and that typo, anything else that we need to add to that from the plaintiff's perspective?
No, Your Honor.
Ms. Brashier, Master, Mr. Brashier, any
No.
objection to that? Okay.
No, you're not.
So number 16, I will do that, and then obviously I'll take off the commentary at the bottom. 17, I think, is just the standard negligence instruction that's found in the, looking at my staff attorney, I think that's correct. We added that.
17 is fine, it doesn't.
Any objection to 17 from Mr. Brashier, Ms. Brashier Best?
Your Honor, where is this instruction coming from?
It is one of the, I think, pattern jury instructions, is that right? Yeah. I'll probably tell you here in just a moment. Okay, it is IDJI 2.20 definition of negligence.
2.2.
Oh, 2.20.
Thank you.
Okay. All right. I'm inclined to give that if the plaintiffs want that. I'm inclined to give that.
Yes.
Any objection to that?
No objection.
Oh, so 17 is okay. All right, I had notes on 18 and 19, so let's talk about number 18. And that was from the IDJI 2.00.1. It was the duty of Defendant James Brashier before and at the time of the occurrence to use ordinary care for the safety of the plaintiffs.
Our argument, Judge, our proposal here, argument is that we should change this to say with the duty of the defendants, plural, James Brashier and Rebecca Brashier, before and at the time of the occurrence to use ordinary care for the safety. And then get rid of 19 would be our proposal. The argument is that this instruction, 18, follows from 17, where negligence is defined as failure to use ordinary care, and negligence is part of Idaho Code 5-311, wrongful death, where it says wrongful act or neglect. So, in other words, in order to be found liable for wrongful death here, again, it can be a wrongful act, an overt act, or it can be neglect, negligence. So the negligence instruction and this duty to use ordinary care instruction should not omit Rebecca Brashier. In other words, we should be able to argue at the end that, again, her email was either intentional or negligent.
Right.
Your Honor, I disagree, as I was not at Rosar's parking lot at the time of the plaintiffs. I had no duty of care to the plaintiffs since I wasn't even at the parking lot.
Well, I think what I hear Mr. Miller saying is that's something, he disagrees with that, he wants to argue that. Here's what I am inclined to do. I think with regard to 18, I would say it was the duty of the defendants, plural, before and at the time of the occurrence to use ordinary care for the safety of the plaintiffs. I do think, though, that I would keep 19. I think if they're going to distinguish between Ms. Brashier Mast's act before and Mr. Brashier's act at the parking lot, well, my inclination was to say if they were going to separate that, I was going to keep that in if there's two different, if her negligence was sending that email and his negligence was doing the shooting.
I guess if you're going to keep 19, Judge, I would ask that you make it parallel, if you would, and have two lines there, basically saying that the negligence of one cannot be imputed to the other, I guess.
What email are we discussing?
Number 19, that's the instruction that says the negligence, if any, of defendant James Brashier cannot be charged to or against the defendant Rebecca Brashier. That was your requested instruction number 3.
Yes, the negligence, if any, yes. Are we talking about keeping that one?
Well, we're talking about keeping it and modifying it to go both ways.
I would be agreeable to that.
So, Mr. Miller, how would you?
I think you could do a separate, another sentence below, Judge. I don't know, I guess there's two ways. The negligence of one defendant cannot be imputed to the other. I guess that would be the simplest way to put it.
That's what I'm thinking.
Yeah, negligence of one defendant cannot be imputed to the other. That's okay.
I disagree with that.
Just agreed to it.
I agree to the negligence. I agree with keeping 19. So we would keep 19?
We would keep 19
Oh, okay.
and we would essentially change it to say the negligence of one defendant cannot be charged to the other defendant.
Oh, I
Is that
agree to
how
that.
Is that how we,
Yes,
or
I
cannot be
agree to that.
imputed?
We just misunderstood you.
Okay.
I
No, that's
misunderstood you,
fine.
Mr. Miller. I apologize.
That's why we're having this meeting. Okay, so I think then 19 then would read the negligence of one defendant cannot be imputed to the other defendant.
Okay.
Keep it at that?
Sure.
Any objection to that?
No objection, Your Honor.
All right. Okay,
Judge,
now 20.
20 and 21 are fine with plaintiffs.
And those are right out of the instructions. Ms. Brashier, Master, Mr. Brashier, any objection to 20 or 21?
No, Your Honor.
So, okay.
22, Judge?
I'm ready for 22.
We would propose, and I know that it looks like I requested this in my list, and that was error on my part. We would propose that this not be given this instruction at all. Proximate cause is not part of Idaho Code 5-311. It just says caused. There's nothing about proximate cause. So we propose that in part of that argument, judges, we don't want to confuse the jury, have them be worried about something they don't need to worry about.
Okay.
Your Honor, I would actually ask this remain in because I was going to actually request this and I saw that the plaintiffs had already requested it, so I didn't want to be redundant.
Do the defendants have an argument for keeping it in?
Well, the words willful and wanton when used in these instructions, I mean, I think it applies to this case.
Oh, I think we're on it. That's a different.
Yeah.
Oh, we're
That
on
was
21.
We're looking at
We're
22.
on 22.
Yeah, 22 is the proximate cause.
Oh, I absolutely want this in.
It's just. Argument is, Judge, that we don't recall seeing proximate cause used anywhere else in the instructions so far to this point. This is just a definition.
This is like a definition of proximate cause.
Right.
Proximate cause is not in any other instruction.
So we don't need the definition.
Okay.
Okay.
Let me, Ms. Brashier, Master, do you have any response to that?
I don't. One or more proximate causes of an injury. 2 or more persons or entities contribute concurrently to this.
So what I hear the plaintiff saying is they're withdrawing that request.
Okay.
You're okay withdrawing that?
I'm okay with withdrawing it.
So we will take out 22, so we will not instruct on proximate cause. Okay. Now, 23.
Plaintiffs are,
23 and 24 are interesting because those are damages. And as I indicated this morning, we've got pattern instructions, a specific one to wrongful death, and then we've got a general damages one. And so we've got, again, I'm looking for some input.
yeah, one issue I have, Judge, I wasn't sure about this either. I know I submitted, I think, both. I wasn't sure exactly which way we were supposed to go on this. I know that section 5-311, I've got it pulled up here, says that when the death of a person is caused by the wrongful act or neglect of another, blah, 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 such damages may be given as under all the circumstances of the case as may be just. So it's very broad in its allowance for damages. It doesn't restrict them to any sort of type of damage or thing like that, just all damages that might be just. So I think that allows us to argue broadly. Instruction 23 breaks it down, non-economic, necessary services and so forth. I don't know if we want to get that specific. In 24 gets specific. It says decedent's funeral costs,
Right.
medical care, loss of services, loss of financial support. Judge, as you know, having heard the evidence, Your Honor, the damages in this case are mostly general damages, not specific damage.
Right.
So, go ahead, Kevin.
No, it's just a-
Yeah, I had that scratched out.
So,
Go ahead, I'm sorry.
and I hear what you're saying, and if we're talking about the wrongful death, the reason, and I suspect the reason you probably included 9.05 is because that's the Idaho specific instruction for wrongful death, which, as I read the statute 5-311 and I look at, for example, in 24, number 3, the reasonable value to the plaintiff of the loss of the decedent's services, training, comfort, conjugal relationship, and society, and the present cash value of any such loss that is reasonably certain. Sorry, I'm reading fast. I meant to say for 20 years, she has really been making me sound far more intelligent than I deserve. And she told me that if she was sitting next to me, she would have hit me a couple of times today. So I recognize that.
Oh, I probably did the same thing.
Yeah, so let that be a lesson to all of you who intend to read something. You gotta go slow. We read faster than we speak. Yeah, so that's what it's going to show up as blah, 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 or unintelligible. That's the other way I've seen it show up. But I do think, to your point, that element number 3 in instruction 24, I think that goes to the more broad general damages. I don't know if that applies to, we've got negligent infliction of emotional distress. We've got intentional infliction of emotional distress. We've also got to talk about the civil liability for death by firearm. And so that's why I've kind of got those broken out. But I will concede, I scratched my head over the weekend trying to decide, okay, are we potentially confusing people with damages?
I think so. I do. I don't have a good idea on what to do at the moment, Judge. I would ask maybe for a little bit more time to mull this over.
I would completely grant you that, because if I can be educated, you can educate me, I'm happy to be educated. But again, I think the way I'm viewing it is we've got an instruction specific to wrongful death in the pattern jury instructions that I think I'm probably compelled to use. Well, that's our safe harbor, is if we use that for the wrongful death. The question is that sufficient for these other elements or these other types of damages?
So we do have a pattern instruction.
We do.
It's the 23 is it?
23 is the pattern, 24 is the pattern instruction for wrongful death. And 23 is the pattern instruction for what they call general damages. This is, let's see, damage instructions for injuries to plaintiff general case. And again, that sounds more in the line of, I think, personal injury, which we're not necessarily dealing with here, not your typical car accident case, which makes a lot more sense when you look at these non-economic damages, those kinds of things. So I am happy. I could see the argument for taking out 23, and the reason I can see that is entitled damage instruction for injuries to plaintiff, and so that sounds, I'm going to say it sounds in tort, but it sounds more like a physical type injury. The traditional, I would expect to see this in a car accident case or your traditional personal injury case.
Right.
But I agree with you, this is confusing.
Yep. Yeah, I think that's exactly right, George. I think that 23 would be traditionally given in a, some ways, in a case where the injured party is bringing the suit.
Right.
The person who suffered a physical injury. I'll,
But, you know, one could argue as well, as I look at this, when I look at, for example, you know, our infliction of emotional distress, both intentional and negligent, you know, the elements of that damage are the physical and mental pain and suffering, past and future. That's certainly consistent with, I think, evidence presented here at trial. One could make an argument with that. So I think that implies, I don't know, you've got economic damages. I did hear evidence in terms of specific amounts that I want to say was John Mast was incurred as a result of some of the medical things. So those do fit in, for example, instruction 23, which is, again, I spent part of the weekend trying to reconcile this, and as I'm hearing the evidence, it's kind of distilling a little bit better. So there is an argument for keeping that in.
Yeah, that's true. That's true. I'll be candid with you, Your Honor. If we look at the bottom of 24, I've got a problem. I understand there's a pattern jury instruction. I'm not sure why they wrote it like this, but death is inevitable. Although the law compensates for the untimeliness of the death caused by another, no damages are allowed for grief or sorrow. Makes it sound like no damages are allowed for pain and suffering, except that you go to the next sentence. There can be no recovery for pain or suffering of the decedent prior to death, right?
And I looked at that too.
Yeah.
And my thought was, this would be potentially relevant if the personal representative were making a claim on behalf of the heirs, which is not happening here.
Right.
Is that your point?
I think so.
One of your points?
I think one of the points I'm making here is that we do agree 100% that John Mast cannot bring a claim, nor his estate on his behalf, bring a claim for his pain and suffering. That's well settled law in Idaho. What I'm concerned about is the jury seeing the sentence above that, no damages allowed for grief or sorrow, and then thinking, well, they can't award anything for pain and suffering. But I think the way this was constructed, the way it was written, I don't think grief or sorrow was meant to be the same as pain and suffering, because they used pain and suffering in the line below.
Right. And they
could have used the same phrase above. So there's some potential for some confusion. I suppose I could just explain it in closing. But I hope the jury doesn't say, well, grief, sorrow, pain, suffering is all the same thing. When that's the lion's share of the damages.
Right. Well, and you look at, I think if you look at 3 and 4 are really the things that you're able to claim, and I think grief and sorrow is different from comfort, conjugal relationships, society, and the present cash value.
Yeah, that's true.
My inclination is not to change it, only because I think it's got the pattern, but I certainly think in your closing, if you wanted to address that, you could certainly make that argument.
Okay.
Ms. Brashier, Mast, any questions or concerns on that?
So we're keeping 23 and 24?
Well, 24 I think is the easy one. So 24 is the specific jury instruction right now that applies to wrongful death.
And then we're
still discussing 23.
Okay.
So my inclination right now is to keep 24 as is, because it's a pattern jury instruction and it's our safe harbor. It's what the Supreme Court is established as the proper instruction. Any objections to include?
No, not at all.
So I'm gonna keep 24. Let's go back to 23 though, Mr. Miller, if the plaintiff still wants that. And that harkens back to our conversation a few minutes ago about, the other types of damages.
Judge, can I ask a question?
Please do.
Being the outsider, and my confusion is the statute's very clear and it ends with that word just, which to me means fair. Whatever damages the jury thinks is fair. And I think Mr. Miller is correct. It's very wide open. And I'm trying to figure out, I'm guessing maybe there was case law or something. I'm trying to figure out how in 24 they got an entire laundry list of what you could get or claim when the statute only says whatever's just. I mean, you see what I'm saying?
I do see what you're saying.
Yeah. So I didn't know if there's a case we could look at.
I know that there, in my code section here, there is decisions under prior law. There's case citations to damages in general, damages in particular cases. I haven't gone through that, although the very first one, I'll just share with you what it starts reading off with. It says the expression, quote, as under the circumstances of the case may be just, close quote, means such circumstances as are properly shown to the jury by the evidence under the pleadings, and the jury should be so instructed. The jury should not be permitted to assess damages on their own ideas and notions of what the circumstances of the case are, regardless of the pleadings and proof. And again, you ready for this? That's a case from 1893. So I think we were a state in 1890. No, we may have still been a territory at that time. I think we were a territory at that time. So
There was a judge, I was at a court in the South. He told one of the attorneys, now don't bring me a horse and buggy case. And that would be a horse and buggy case from that old.
I have to tell you, I sat at a conference with a judge from Iowa some time ago. I think Iowa is one of those states, and I don't know if Arkansas is as well, but they have probably 100 and something counties. They're just little squares.
Yeah.
And I think they called her a circuit judge, which meant she had a circuit. And I said, well, where is your home base? I've got an office, and I know where I'm at. You know, if I occasionally hear cases in the district, and she says, I don't really have one. She covered 5 or 10 counties or something like that. I said, tell me about the counties. And she said the counties were designed so that someone in a horse and buggy could get from any point into the county seat in one day's travel.
Oh, wow.
And that's how they came up with these very small counties. That's, I guess, your piece of trivia for the day. And that was, but you talk about horse and buggy, and I thought that was interesting. So anyhow, we digress.
What about, Your Honor, replacing number 24 with simply the language from the statute regarding damages? It's not very long, but it is, I mean, we have a statutory basis for it.
And we could just say, in every action instead of saying under this section, in every action for wrongful death, such damages may be given as under all the circumstances of the case as may be just. And leave it at that. Instead of 24.
Again, the concern I have is I have a specific instruction on wrongful death. That's the concern I've got.
Your Honor, if I may, for the record, just so that we're clear, since we're making a record here, I'm going to formally ask on behalf of the plaintiffs that we replace instruction number 24 with the sentence from the statute as I just quoted it, and just make that a formal request for the record.
All right, I'm going to take that under advisement.
Understood.
Right. So I'm hearing, as I understand, the defendants do not have an objection to the standard instruction. They now want to replace that with just how the statute reads.
That's correct, Your Honor.
Let me take that. I'll take that under advisement.
Oh, that's true.
Okay.
Judge, instruction number 23.
Okay.
That we have it. I guess we should read 24. Doesn't work.
Okay.
That's okay. That's okay. Yeah, I think we can be okay with 23.
Okay.
And I'm going to stand on my request
For 24. Understood. And then again, and the bracketed material in the proposed 23, those are my words, and I just had put that in there to differentiate that from the wrongful death statute.
Right.
Ms. Brashier Mast or Mr. Brashier, any objection to 23? That was just the general damage ones.
No,
Okay.
nothing, no,
And Mr.
No
Brashier, okay, so
objection.
23 is okay. We need to have further discussion on the, what I'm going to call the wrongful death damages. No. Okay.
He's taking legal advice, so yes.
Yeah, I want to go look at that. I want to just spend a little bit more time with that. And again, I recognize probably the biggest hangup I've had on these instructions is kind of the damages side of it. It's.
Well, Mr. Hickey wanted to talk to me for a minute, but.
No, go ahead.
But what, something,
Yeah.
take it under advisement, we'll have time, unless you want to take it up right now.
You want to operate?
Yeah.
Any further argument on that?
If I can have a minute, Mr.
Yeah, go ahead. Go ahead.
Okay. We'll be right back.
So 23 and 24 are now,
23, yes, 24 I've got. They're asking to modify that.
yes.
And I haven't made a decision on that.
Okay.
I'm going to step out with my law clerk for a second. We'll be right back. Let's just take a break off the record. All right. All right, we'll be back on the record. Again, this is Mast v. Brashier, CV 35-23-195. The parties and their attorneys are present. Mr. Brashier, Ms. Brashier Mast is present. Looking at 24, we're going to find out if this is a situation where the IDG, the pattern jury instruction, just hasn't been updated. We've run into that in times past, so we're going to track down some session laws, I think, from 84 to see if that is. So I'll take that under advisement. We run into that a time or two where I ran into it in a criminal case where the criminal pattern instruction hadn't been changed, and I just happened to catch it in the middle of a trial. So it wouldn't be the first time. So we'll take that one under advisement.
Okay.
Look at that. But to your point, I see your point. I guess is I understand what you're saying. So
Somebody needs to take that up and get that changed.
yeah, the museum.
Yeah.
Okay. Okay. 25.
25 is fine with plaintiffs.
And 25 is my attempt to take into account the allegation in the complaint for, it was 18-3307, if I'm not mistaken.
Yes,
Make
that's
sure I got that correct.
That is the right number.
All right, so, and Ms. Brashier, Mast, and Mr. Brashier, that is the statute that is titled Civil Liability for Injury by Firearm. Any party maimed or wounded by the discharge of any firearm aforesaid, or the heirs or representatives of any party who may be killed by such discharge may have an action against the party offending for damages which shall be found by a jury, and such damages, when found, may in the discretion of the court before which such action is brought be doubled. And so this is an instruction that essentially identifies that statute. And it indicates that to establish civil liability, you must find that defendant James Brashier killed John Mast by discharge of a firearm, which I think is an accurate statement of the law. So plaintiffs are okay with 25. Any objection to 25?
No, Your Honor.
Okay. Mr. Brashier, any objection to that?
May I just ask a question?
You may.
Those words that you read are on 26. Is that a follow-up or?
We're on 25.
If you just read this. It's the same thing as 118.
So 25 identifies essentially the statute. 26 is an instruction that talks about having been previously convicted for the offense of voluntary manslaughter. What I would instruct the jury to establish as true is that you caused John Mast's death. And so what they would be left to determine would be whether or not that occurred by a firearm. I don't think I can instruct them on that. I think that's a finding that they need to make on their own.
Correct.
So 25 is just simply it identifies the code section. Any objection to that? Okay, so 25 is okay. So that, again, that takes us to 26.
We're fine with 26.
Okay. Ms. Brashier, Mast, or Mr. Brashier, any issue with 26? It's essentially to a certain extent, a copy of 14. And again, it reads as follows. You are instructed that the defendant, James Brashier, in this case, has been previously convicted in a criminal proceeding of the offense of voluntary manslaughter for causing the death of John Mast. In this case, the defendant's prior conviction for voluntary manslaughter conclusively establishes the following fact, which you must accept as true. 1, defendant James Brashier caused John Mast's death. Therefore, for purposes of determining civil liability for causing death by firearm, you must find that the defendant James Brashier caused John Mast's death. Your role as jurors is to decide whether defendant James Brashier caused John Mast's death by discharge of a firearm. If you find that he did, you must then determine the amount of damages, if any, that should be awarded to the plaintiffs based on the evidence presented during this trial. And again, that is just my attempt to alert the jury that we have this issue of claim preclusion, but that still leaves the issue of determining whether or not it happened by a firearm and damages, if any. The jury could conclude that it happened by a firearm and not award any damages. So it's kind of a two-part process.
I guess my concern was it's repetitive because it's in 14, like you said, and now it's in 26.
It is in 14, but I put that in there just because they need, I think it's fair for them to be aware that through the criminal case, it was determined and they have to accept as true that you caused John Mast's death.
Okay.
That's the only reason I have that in there. So
Thank you.
To the extent that there is an objection to that, based on that, I'm going to overrule the objection for the reasons I stated on the record. But other than that, any objections to that?
No, Your Honor.
Okay, so 26, I'll put that as okay. All right. 27 is a standard instruction, just it states, by giving you instructions on the subject of damages, I do not express any opinion as to whether the plaintiff is entitled to damages. I think that's just to make sure that that they know that that's not my role, is to tell them whether they're entitled or what they are. So that's standard one out of the pattern jury instructions. Any objection to that?
None, Your Honor.
6.7, okay. Now, I have a potential 28 that we worked on, and it was brought up by the fact that Mr. Brashier invoked his Fifth Amendment right in Alderson v. Bonner, 142 Idaho 733. It is clear that you can draw negative inferences in response to a question if a witness invoked the Fifth Amendment right, and it's old enough that I couldn't get into the case to find the actual jury instruction, but there was a jury instruction produced in that case, and we don't know what it said, but the proposed, because I suspected you were going to ask for something along those lines.
Yes, you did.
My proposed language is, quote, you may draw negative inferences if, in response to a question, a witness invoked the Fifth Amendment right against self-incrimination. I don't know if you have better language. Again, this is, do you have something that you want to suggest?
I haven't found anything yet in the hour that we had. I'm good with that so far. If I find something else tonight, I'm going to propose it in the morning.
We probably ought to do that, and what I can do is I can, I think before the end of tonight, I can figure out what we're going to do with the wrongful death.
Can you read it one more time?
I sure can. You may draw negative inferences if, in response to a question, a witness invoked the Fifth Amendment right against self-incrimination. I could probably write that more clearly.
Yeah, I think there's maybe another element or two to add to that. I just don't know what it is off the top of my head, but if I could look at that tonight.
Would you do that?
Yeah.
Okay. I do find that some sort of instruction is appropriate under the circumstances. I think that's clear from the case law. Question will be what is it to be?
Very good.
So, okay. Now, I think that takes us to the algorithm.
But we can also skip ahead and look at
which is going to change.
Yeah, 29.
All right, let's go. Let's skip 28, which is what I'm terming my algorithm. That's my series of questions and how to move through that. Let's go to 29.
Because we have no issue with 29, 30, 31, or 32.
And Danny, those are the standards from these.
Yeah.
Okay. And I'm told these were my staff attorney helped me put these together. I'm told that 29, 30, 31, and 32 are the standard straight from the pattern instructions. So any objection? Let's just go through them individually. As to 29, basically says in deciding the case, you may not delegate any of your decisions to another or decide any question by chance, such as a flip of the coin or drawing of straws. If money damages are to be awarded, you may not agree in advance to average the sum of each individual juror's estimate as a method of determining the amount of damage awarded. And that's straight out of the, any objection to
No
that?
objection, Your Honor.
29 is okay. 30 is a very standard one that just tells them that if they need to communicate with me, they can send a note. Any objection
No
to that?
objection, Your Honor.
Okay, so 30 is okay. I will tell you my standard practice if I get a note from the jury is to come back on the record, put it on the record, and then we talk about how to respond to it.
Great.
31. Again, that's that's out of the pattern instructions. Any objection to that? Okay. And then 32 is also, it's really my concluding instruction, and that is straight out of the pattern instructions as well. Any objection to that?
No, Your Honor.
All right, so then when the dust settles, it is instruction 24 that I need to look at.
Right.
And then we have what I'm calling 28, which is, right now it's 28, that could change. That may end up being 29 because we're potentially going to insert this other one with regard to invoking the Fifth Amendment right against self-incrimination. I can tell you right now, it's going to change because I think question 1, for example, on the verdict would be, did Rebecca Brashier Mast commit an actionable wrong against the decedent? Yes or no. Question 2, if yes, did that same actionable wrong cause the decedent's death? Oh, I'm sorry. Where did I leave off? The second question is, if you answered question 1, yes, did that same actionable wrong cause the death? Yes or no? And then the new question 3 would be, what is the amount of damages the plaintiff Robert Mast is entitled to receive for the wrongful death of John Mast? And I think we need to clarify that.
Yeah.
As to,
I
is it the wrongful death of John Mast by Rebecca Brashier Mast?
Yeah, I said, or due to Rebecca Mast, or Brashier's wrongful act, something like that. I agree, Judge, I put something in there. And basically, Your Honor, what I did, I was kind of getting lost in this a little bit, and I thought, I got to diagram this out, you know. And so I did kind of the same thing, though, and it seems like you've got the same 3 questions, right, that you have there for wrongful death, James Brashier to Robert Mast, then wrongful death, Rebecca Brashier to Robert Mast.
Right.
Same 3 questions, right? Then you can move into the intentional infliction of emotional distress, but you're going to have, this is going to get quite long, I would think, because do we have to have, or do we, I guess, like the same 3 questions more or less, right?
So when I look, for example, let's take intentional infliction.
Okay.
And that is instruction, right now it's let's look at the elements as outlined in instruction number, it was number
16.
Yeah, number 15, okay, thank you.
Sorry, what was that number?
Number
16 for intentional.
16 for intentional. So for example, let's look at intentional.
Okay.
I think we only need to ask one time, well, it's going to be one as to each. For example, was Defendant James Brashier's conduct intentional or reckless? Was Rebecca Brashier Mast's conduct intentional or reckless? Same thing with regard to extreme and outrageous. And then we only need to ask that once because it either is or is not, right? And then the next question is there a causal connection between their conduct and each of the plaintiff's emotional distress? We could repeat it several times if you think that was more clear, but I think when I originally looked at this, I thought the jury, they're either going to give us a yes or no on whether the conduct was problematic as as contained in elements 1 and 2.
Well,
How do you suggest it? I'm open to suggestions.
What about for simplification, though? On the verdict form, rather than having a yes/no question for each of the elements, I'm not sure that we need that. It's going to get very cumbersome. Can't you just say something like, was the defendant James Brashier's, let's see,
Sorry, where are we again?
We're looking kind of generally at proposed instruction 28. That's,
Okay.
I've been calling that the algorithm. That's the,
Okay.
if you answer this yes, go to this question. That's, and this is a little bit more difficult to see simply because if you look at the verdict sheet, each of these is on a separate page. So would it be helpful if I printed out the verdict, kind of the proposed verdict as it stands? It might be easier to see it than just going through, I don't know.
well, I was going to say, Judge, couldn't we say, did defendant James Brashier cause or inflict intentional, how do I say this? Cause the intentional infliction of emotional distress on plaintiff Stephen Mast. And then you do the same thing for James Brashier to Betty Troyer and to Robert Mast. So you can have 3 of these, right? 2 questions.
So they're either going to answer yes or no.
Yes or no, and then if yes, damages. Did they cause intentional infliction of emotional stress to this person? If yes, how much? If no, then move on to the next one. Did this person cause intentional infliction of emotional stress to this person? If yes, how much? If no, move to the next.
It would certainly simplify things because the elements are there. They're going to be this is what you have to do, and they're going to say, do you meet the elements or do you not meet the elements?
Right, exactly right. That's what I would propose, because even then, it's still going to be a lengthy form.
Right.
To go through several questions. But then we break it up between each defendant to each plaintiff,
okay.
Right? But only 2 questions each time.
Okay.
Did you do this?
I'm following you.
Okay, yeah.
This is. You can imagine when we're doing the criminal stuff, it's a little different.
It's a lot simpler.
It's a little different. That's right. Do you hear what he's saying?
I do understand it.
And so it would just be a yes. Essentially, they would look at the elements, and based on that, they would say either yes or no. They met the elements, and if the answer is, and if the answer is no, they move on. If the answer is yes, they fill in amount.
Yes, Your Honor, I do understand. And I agree, it would be more simple.
Okay.
It would it would help to not confuse the jury as much.
Okay.
Good idea.
It's a
I'm
good
okay
idea.
with that. Again, if I could describe to you my Saturday and then my Sunday as I wrestled through this.
I'm so sorry.
But this is the advantage of sitting together like this, because I wish I had that opportunity to do that, because I could have gotten some of my Saturday and Sunday back.
I will tell you, Judge, that I've told Mr. Hickey that I put a request out on my listserv a couple of weeks ago. Like, anybody have any verdict forms? Crickets. I got nothing.
Well, I will tell you that I called a number of district judges as well, and nothing. Other than Judge Whiting says hello.
Oh,
so
all right.
Thanks. He and I went to judge training together, which is how we met. So, but I know that he had as I understood, a fairly robust civil practice, and I thought he might have run into this once or twice. So, okay, I like the idea of simplifying that. So, I think we can work on that, and I think we can look at that as to, if we do that as to negligent infliction, intentional infliction. I think we can cut a lot of the fluff out.
I think so. 2 questions on each one of those, and then corresponding people, and then do the same thing with negligent, and it'll be fewer questions because Robert Mast is not included there.
Right.
And so, and then I think it's the same thing with death by gun.
Yeah, and as I think about that, that makes sense, because in the criminal context, we give them all these elements, and the question is just yes or no. right? They either,
True.
they either say guilty or not guilty, and so they don't parse it out individually.
They don't. That's exactly right. That's a good point. However, the difference also in the criminal case is that if any element is not found, they have
They
to
must
say
say them.
Yeah.
Okay, I like that. I think I will change that. And then you're suggesting, I think I am going to ask them with regard to the 18-3307 damages, if a firearm was used, and then an amount.
Correct.
Right,
That's
I
the
think
same thing. Two questions.
Yeah, 2 questions.
That's right. Yeah.
Okay. All right, we've covered a lot of ground. What am I missing?
On instructions, I don't think anything.
Ms.
May I
Brashier?
ask a question?
Please.
Does a firearm pertain to me in any way, shape, or form?
No,
Okay, thank you.
not in my opinion. Is it, do you guys? Okay. So. All right. Let me do this. It's 4 o'clock. I think what I'll do is if you can, well, I hesitate to do it, but I'm not really. Why don't we get back together here in about 45 minutes? Now, Mr. Brashier, I don't know if you need to be transported back or, right, I don't know if you need to go, but,
Sir, I'm here as long as you keep here, sir.
all right. Well, I appreciate that. I was gonna say, if you needed to get back, we could reconvene and I could just put Mr. Brashier up by Zoom, but, I think it's easier if he's here. Let me go back, hang tight. I'm gonna make a couple of changes and see if I can get you some revised instructions. I don't know if you're welcome to stay in the courtroom. You're welcome to use one of these rooms back here. We'll come find you and get you kind of updated versions. But to the extent that we can continue to talk about this so that we can get started moving tomorrow.
Are we gonna finish the jury instructions then when you come back?
I would think so.
Okay.
I would think so.
Mr. Honor.
You wanted to
Motion reconsider.
be heard on a reconsideration on the punitive damages issue.
We can do that when you come back.
Let's do that when I come back.
Okay.
All right. So I'm going to step off the bench. We're going to work on this a little bit and then don't go too far. By the way, why don't we get your numbers? Will you leave your cell numbers with my clerk, everybody, so that we can do that? Oh, yes. And one other thing. When it comes to reading these instructions, does anybody have an objection if my court reporter doesn't have to record it? It will be recorded for the record, and they're going to be written. It just saves her time and energy and
You don't have to read. Yeah.
probably frustration. And I can go faster. So, all right. All right.
Yeah, sure, yeah.
Oh, he's coming out.
Yeah, the judge back there, he just wanted me to give you guys this note.
Oh, he's gonna give it to you.
Yeah, he's still kind of working his way through it. It's surprisingly complicated what we're running into.
Which one are we talking about?
For the wrongful death.
Did you find one today?
No, it's been the same.
It's still working on it. It's
Oh,
still
yeah.
out.
Yeah.
Still in one world. So we're talking about 24.
Yes, 24. So yeah, the rule that we're looking at.
He doesn't have his listening
Oh,
device on
sorry.
yet. I
Sorry.
apologize.
No, not at all. Idaho Rule Criminal or Civil Procedure, I'm sorry, 51G.
Okay.
And then the specific case where they kind of launched into talking about damages and there's a FAU, it's a PFAU, Ware Holdings Inc. The site is 135 Idaho 152 2000. Yes. And it's kind of getting us a little bit deeper into figuring out why the HE is the way it is. It looks like they kind of reference.
Could I see that to write it down?
Yeah.
I apologize.
You can read my handwriting, sure.
I absolutely can.
It looks like there was an old version of the HE that I'm trying to see if I can find that maybe had an explanation out. Got where they got, so.
Okay.
You said, what's the procedure 51G?
51G, section G.
Was he wanting us to do that now?
He just wanted you guys to know that if you wanted to do your own looking, before he gets out here. Yeah, no problem. But be out as soon as you can.
Okay.
Yeah.
Apologize, please be seated. Take that. Verdict form. Okay. Yeah. There it is. Copy of each for
Thank
that.
you.
But is what copy of each for that. All right. Okay. Okay. We're back on the record in Mast v. Brashier, case CV 35-23-195. Parties, please counsel for the plaintiffs are present. I see Mr. Robert Mast present. I think two of the other plaintiffs may have stepped out. Oh, they are both here. They're just in there. They're just not at counsel table. Okay, so I just want to make sure plaintiffs and counsel are here. Mr. Brashier is present as well as Ms. Brashier Mast are present. Okay. We again are outside the presence of the jury. Ladies and gentlemen, what I've tried to do is work on the jury instructions a little bit. So I got the verdict form, which what I've done is I've tried to simplify that to just straight yes, no questions. Those are going to turn into that instruction 20. Well, it was instruction 28. It's got a blank there now because we'll have to fill that in. But I've made the other changes. So let's go through those quickly now.
Your Honor, these, on the verdict form?
Correct.
Oh, did you say we're gonna go through it now?
We can.
Oh, okay.
What I did was rather than go through it, I've been calling the algorithm. I worked on the verdict form because if the verdict form is correct, then what I'll do is I'll translate that into the jury instruction. But I wanted to, it's easier for me to see the flow as I go through page by page. So what I did on that, question 1, did Rebecca Brashier Mast commit an actionable wrong against the decedent John Mast that caused John Mast's death? And that's either a yes or no question. What I did on that is I just combined the elements like we had talked about.
Yep.
And then if so, go to question 2, enter an amount. If not, go to 3.
And these blank lines, that's for each of the jurors to put
Correct.
names? Is that
Right.
just for polling the jury because we
Well,
don't need?
so if you look at the last instruction, it was 32. It says, and this is IGE 1.15.1, a verdict may be reached by 3/4 of your number or 9.
Right.
As soon as 9 of you or more have agreed, you should fill it out as instructed and have it signed. It is not necessary that the same 9 agree on each question. If your verdict is unanimous, the presiding juror alone will sign it. But if 9 or more, but less than the entire jury agree, those agreeing will sign it. So,
Okay, yes.
and that's why there's 12 lines on
So
each one.
only the ones that vote, for instance, yes, they're, only those will
Right.
sign.
Correct.
So we're looking for 9 signatures.
We're looking for either just one signature for the presiding juror, which indicates that it was unanimous, or we need 9 individual signatures indicating that 3/4 of the jury agreed with that.
Gotcha.
Does that
Thank
make
you.
sense?
Okay, all right.
And so that's how I've set this out on each of these. So, but question number 1 is just a straight up and down wrongful death as to Rebecca Brashier Mast. Question number 2 is, if so, fill in an amount. Question 3 relates to the damages with regard to James Brashier. And then question 4 is the intentional infliction. Question 4 states that James Brashier intentionally inflict emotional distress on Robert Mast. If you answer yes, go to 5. If you answer no, go to 6. 5 is, if so, what's the amount? Question then 6 asks, did James Brashier intentionally inflict emotional distress on Stephen Mast? Yes or no? If you answer that, yes, move on to 7, which is the damages amount. If you answered no, skip that and go to 8. 8 is, did James Brashier intentionally inflict emotional distress on Betty Troyer? Again, that's a yes or no question. If you answer that yes, go to 9, which is the amount of damages. If you answer no, skip that and go to 10. And then, let me make sure I've got that right. 10 is and 10 is questions with regard to Rebecca Brashier Mast. Did Rebecca Brashier Mast intentionally inflict emotional distress on Robert Mast? Yes or no? If you answer yes, go to 11. If you answer no, go to 12. 11 is the amount of damages. 12 asks, did Rebecca Brashier Mast intentionally inflict emotional distress on Stephen Mast? Yes or no? If you answered yes, go to number 13, which is the amount of damages. If you answer no, skip that, go to 14. 14 is, did Rebecca Brashier Mast intentionally inflict emotional distress on Betty Troyer? Again, that's a yes or no question. If you answered yes, go to 15. If you answered no, skip that and go to 16. Question 16, that starts the questions regarding negligent infliction of emotional distress. Again, did James Brashier negligently inflict emotional distress on Stephen Mast? Yes or no? If you answer yes, go to 17. If you answer no, skip that, go to 18. 17 is the amount of damages, if any. 18 is, did James Brashier negligently inflict emotional distress on Betty Troyer? That's a yes or no question. If you answered yes, go to 19, which is the fill in the blank for the amount. If you answered no, skip that and proceed to 20. 20 then reads, did Rebecca Brashier Mast negligently inflict emotional distress on Stephen Mast? Yes or no? If you answered yes, go to 21, which is an amount to fill in for damages. If you answer no, skip that and go to 22. 22 is, did Rebecca Brashier Mast negligently inflict emotional distress on Betty Troyer? Yes or no? If you answer yes to that, go to 23, which is the line item for damages. What is the amount of damages Betty Troyer is entitled to receive? And then we go next to 24, which is the civil liability for death by firearm. 24, did Defendant James Brashier kill John Mast by discharge of a firearm? If you answered yes to that, go to 25. If you answered no, you're done, sign it and inform the bailiff. And then 25 is, what is the amount of damages plaintiffs are entitled to receive because John Mast was killed by the discharge of any firearm? And I already see a typo there. Change that to. So that's the shortened version. It looks like we knocked out 13 questions. My math is correct. Any objections? Is that, and I'm presuming, Mr. Miller, that's what you were referring to.
That's exactly right, yeah.
Okay.
I like it, Judge.
I think we're good with all of those, Judge.
So what I would, and is that,
I agree with it.
okay, Mr. Brashier, is that, okay. And I think, I appreciate you bringing that. I knew I was looking for something this weekend when I was doing that, it's the former accountant in me, I think, that was just going down the thing. So what I will do, this will turn into that, what was our original or proposed 28 that had, again, I'm calling it the algorithm. I will just translate into that. So let's now just walk again through the instructions that I provided to you as I walked in are cleaned up versions. Again, 1 through 6 are pre-proof instructions. Looking here, 7, 8, and 9, there were no changes to. 7, 8, 9, 10, 11. There were no changes to. 12, there was no change to. 13, there was no change to, other than I've cleaned up and I've taken all the superfluous information from the bottom of that. Okay, 14 was the first one that I changed. And I already see that I failed to change actionable wrong to wrongful act. I will make that change. And then the other change was last sentence, defendant Rebecca Brashier Mast was not charged with or convicted of any criminal act relating to John Mast's death. And so that was what I put in there. So again, I apologize. I felt a little crunched for time back there when I was doing this because I knew all you folks were waiting, so I missed this. So I will change actionable wrong to wrongful act in the paragraph right after the number 1.
Thank you, Judge.
15, I corrected the spelling, but otherwise that is, I think, as we agreed upon. 16, I correctly spelled emotional, I think at this point. And I also added the plaintiffs, Robert Mast, Stephen Mast, and Betty Troyer. So I added Robert Mast to that, as we talked about. 17 remains unchanged. 18, pursuant to our conversation earlier, that now reflects it was the duty of the defendants before and at the time of the occurrence to use ordinary care for this. Say the negligence, if any, of one defendant cannot be charged against the other defendant, as agreed. Let's see, 20 was unchanged, 21 was unchanged. I removed 22, so the new instruction 22 is the old 23.
Okay.
So Ms. Mast, if you'll, I just want you to be clear, and Mr. Mast, that because we took out the proximate cause instruction, just to make a consistent numbering, the old 23 is now our current 22. And I just cleaned that up, and I don't think any other changes were made to that.
Let's just say cause.
All right. Now we come to, and I left blanks on these because Mr.
The word approximately is still in instruction 22.
Is it still in 22?
We're wondering if it just should say in that first paragraph, for any damages proved to be caused by the defendant's negligence.
Because we took out the definition of proximate cause.
Okay. Any objection if I make that change?
No, Your Honor.
Okay. So I'm going to strike that. Okay.
Why is there no numbers at the top?
Because we still hadn't discussed 24, whether that was going to stay or go. And so I just left the blanks on there because depending on what we decide, they're going to need to be renumbered. Anyway, so this brings us to, we were talking about 24 earlier. I think my law clerk came in and alerted everybody to some case law as well as the rule of civil procedure that I think I'm bound by, 51G.
Yeah.
That talks about this. I think I recognize you have made a motion to alter that.
Yeah.
I'm going to respectfully deny that. I'm just going to go with the what I consider a safe harbor, the instruction that looks like it was pretty clearly written by the Supreme Court. I'm not going to explain their rhyme or reason for why they did what they did, but the case law, there is some case law about some of the different damages, and in the category of what it's worth, I know the people who are on the jury instructions committee, I'm going to have a discussion with them when I next come to Boise. Let them know that we maybe need to rethink about this. But I think until then, I'm bound by 51G, and I think there's some case law that suggests that I think there is some limits to the types of damages that you can claim on that. So I am going to keep 24.
Understood, Judge.
Now, that being said, I think obviously recognize your objection for the record. I think you are free to distinguish that as needed. Any other changes that you want me to consider in terms of 24?
No, Your Honor, thank you.
So that will be 24. And 25 was, under Idaho law, a person who causes the death of another through the discharge of a firearm may be held civilly liable for damages. We're in agreement with that. That will remain 25.
Yep.
remains the same. 28, you'll notice, 28, I have that, that was my attempt at what we talked about in terms of the invocation of the Fifth Amendment right against self-incrimination. I don't know, Mr. Miller or Mr. Hickey, if either of you have any better suggestions.
No, I think it's,
I'm open to it.
I think it's fine, Judge. I think on reflection, I think it's fine.
Okay.
Thank you.
So that will be 28. Now, I want to make sure you've had an opportunity to lodge any objections that you feel appropriate on that one as well. So,
I have no objections tonight.
okay, so 28, and again, to be specific, that instruction reads, you may draw negative inferences if, in response to a question, a witness invoked the Fifth Amendment right to against self-incrimination. And what I hear you say, Mr. Brashier Mast, is you have no objection. Is that correct?
I have no objection.
Mr. Brashier, do you have any objection to that?
No, Your Honor.
Okay. All right. 29 is blank, and what I will do is I will translate the questions in the order from the verdict sheet that we just went through, the verdict form, into that. I intend to just go over with them what it is, but I'm not going to have all the signatures in there. It's just going to be the question, answer, that kind of thing.
Yeah.
All right.
Right.
So I'll translate in there. I will make sure you have a copy of that tomorrow morning, because even though we're starting at 8:30, I think I'd like to get together at 8 o'clock again. I want to make sure that we're up and running by the time we get to the jurors. So
Great.
okay, so that will be 29. Let's see. The old 29, which is going to be our new 30, which is in deciding the case, you may not delegate any of your decisions. Ms. Brashier Mast, that was the previous version, that was 29. Because we added that extra jury instruction, that's now going to be instruction 30 in the packet that will go to the jurors. Does that make sense?
Yes, Your Honor.
Okay. All right, and everybody was okay with that? And then 31 will be, the one we agreed to with regard to communicating with the court. 32 will be, I've given you the rules of law that apply to this case, and then 33 is the final instruction. Are we good?
Yes.
With regard to jury instructions. All right, well, at 8 o'clock tomorrow morning, it appears to me that we have resolved any objections from either part, from all of the parties with regard to any of the jury instructions at this point. I intend tomorrow, though, at 8 o'clock, to ask if, just to clarify, because once we get the go-ahead, I'm going to print copies for everybody. So.
No, you're doing
Oh.
good. I dropped mine.
By the way, at 8 o'clock tomorrow morning, we are going to convene in courtroom 5.
Oh, right.
I told you, you're going
We're
to see,
getting a tour.
you're going to see every room in this building.
Can we do 6 tomorrow too, so we don't have to come back Friday, Jess?
I'll see what I can do. I'll see what I can do. So, but I'm told it's just, we've been fortunate because we've got 5 judges here, 2 of them have been on vacation. And so I've had free reign over kind of the courthouse. Tomorrow that reign ends, as I understand it. So, all right. Mr. Miller, you wanted to address your motion to reconsider on punitive damages.
Thank you, Judge. Your Honor, plaintiffs are bringing a formal motion to the court to reconsider its ruling on our motion to amend to add a prayer of relief for punitive damages. As the court knows, as we talked a little bit earlier during our instruction conference, and as the court is aware from the evidence,
This case has relatively little in the form of special damages. Most damages here are general damages. Many personal injury cases, as the court is aware, have high specials involved. Specials are often how general damages are calculated. We don't have that here, so we don't have, say, a normal or traditional method of calculating the damages in this case where they're mostly pain and suffering. It's one point I wanted to make here, Judge. Another point I wanted to bring up to the court as I thought about this. I'll be candid with the court again that this woke me up this morning about 4:45 as I was thinking about this and couldn't go back to sleep as I was thinking about a number of issues related to this. One of these issues, Judge, is that the plaintiffs had no control over what was filed in this case. They relied on their lawyers in this case, to file the pleadings for them. Disallowing punitive damages then is ironically a form of punishing the plaintiffs for something that was outside their control. This was something that was on my shoulders to get done, Judge, and I will certainly fall on my sword, having relied on the case law and the statute as I looked at it that seemed to indicate to me there was no time bar to specifically a motion to amend for punitive damages. Understanding the court had a scheduling order, of course, I knew that, obviously, but what I read seemed to indicate that motions to add punitive damages fell outside of that, since there was no time bar limitation. I'll come back to that in just a minute. The plaintiffs had no control over that, Judge, and I think it would be unfair and work an injustice to them to not allow the punitives, prayer for punitive damages here when they had no control over that. Judge, turning to the scheduling order, we understand, we know that the purpose of the court scheduling order is to make things fair to both sides in the conflict and to also make things go smoothly at trial. Denying the defendant's so where I'm coming from this, Judge, to give you kind of a better idea is that I don't know if this is the case or not. Monday morning, the court was considering two different motions to amend. One from the plaintiffs to add punitives, one from the defendants to add a counterclaim for libel. Both of them were denied. I had a sense, Your Honor, and I don't know if this is right or not, that the court, in abundance of caution and interest of fairness to both sides, denied both on the same basis for being untimely and not complying with the scheduling order. But there's some important differences between these two motions that were filed here. Denying the defendant's motion to bring a counterclaim for libel is inconvenient for them, but it's not unfair or prejudicial to them. Denying the plaintiff's motion, though, is unfair and prejudicial, and I'm going to come back and explain why that is here in just a moment. That's talking about this issue of fairness to both sides. When we talk about the scheduling order and the one rationale for that is to make things go smoothly at trial and during the pretrial process, allowing the defendant's motion in this case, Judge, would have definitely muddied the water as to the issues in plaintiff's complaint and potentially confused the jury and made trial much more complicated and less smooth, would have required a whole different set of witnesses, more time to the trial and so forth. Allowing the plaintiff's motion for punitive damages requires no different witnesses, no more evidence, no different evidence than the wrongful death claims, because it's only a prayer for relief. It does, however, deny a key element of damages to which the plaintiffs are truly entitled in this case. I want to talk a little bit more, Judge, about the difference between the plaintiff's late filed motion to amend and the defendant's late filed motion. Plaintiffs filed a motion to amend for punitive damages after the prescribed date in the scheduling order. Defendants filed a motion to amend and add a counterclaim for libel after the prescribed date. So it might seem fair in the interest of justice to deny them both, but key differences here. Regarding for the motion for punitive, Judge, when our motion was filed on June 29th of this year, a month before trial, defendants still had the requisite 14 days to respond and object before trial, and they did. Even if they didn't
respond, and object. And even if the motion to amend was granted due to their failure to object, they still would not have been prejudiced because the plaintiffs still have to prove punitive damages at trial. Not only that, but proof in punitive damages is a higher burden than we have for the rest of the case, for the rest of the claims, wrongful death and the emotional distress claims. We know that those claims are a more likely than not basis, a preponderance of the evidence basis in terms of our burden. When it comes to punitives, the burden's higher. It's clear and convincing evidence that has to be presented. So even if the defendants had not objected, which they did, even if they had not objected, that doesn't make punitive damages automatic in our case. We still have to prove the punitive damages to a higher burden, clear and convincing, and prove all the elements that are required under punitive damages. We have to prove extreme and outrageous conduct and so forth. Now, when we compare that, Judge, to defendant's motion for a counterclaim, when their motion for a counterclaim was filed on July 21 of this year, the plaintiffs did not have the requisite 14 days to respond to a motion or the 21 days to respond to a counterclaim. And unlike punitive damages that still have to be proven at trial, the elements of a counterclaim can be deemed admitted if not answered without putting on any evidence. So there's a big difference here. Even if they hadn't responded, that doesn't change anything. We still have to prove something. If we had not there's a big difference between these two motions that were filed, and they should not be denied on the same basis, right? They can be denied for different bases because of the nature of the motions. If we look at the rules governing the filing of these two different motions, Rule of Civil Procedure in Idaho 13 governs counterclaims. Now, there's two different kinds of counterclaims that can be filed. There's compulsory and there's permissive. If we look at their counterclaim as compulsory, that counterclaim must be filed with their answer. It's a compulsory counterclaim if it arises out of the same transaction or occurrence that is the subject matter of the opposing party's claim. If that were to apply here, and I don't think it does, then defendants were required to file their counterclaim when they filed their answer in March of 2023. If this is a permissive, if we look at this as a permissive counterclaim, which I think it actually is, it can be filed at a later date. If it doesn't apply, they can file their, if that does apply here, then Judge, they can file their claim for libel at a later date in a separate lawsuit. And this is what I think woke me up this morning, is the court's use of the term claim preclusion yesterday when we were talking about a totally different issue. But as I researched claim preclusion last night, I started to see an application here, Judge. Denying their motion to add a counterclaim does not prejudice them because they can bring that counterclaim later, because their counterclaim does not arise out of the same transaction. Their counterclaim, as I understand it, is an allegation of libel and slander, of defamation, basically, against the plaintiffs for putting up posters in Lewiston and for posting things on social media that they consider defamatory. That does not arise out of the same transaction as the event in this case, which is the shooting of John Mast at the Rose parking lot. Different occurrences, different transactions. That makes their counterclaim permissive, which means they can bring it later, which means denying it here does not prejudice them. It just inconveniences them. But it doesn't prejudice them because they can bring it any time later that they want, as opposed to the plaintiffs. If their claim or their motion to amend for punitive damages is denied, claim preclusion means they can't bring it later. It'll be res judicata, and they will not be able to raise it again later. This is their only shot. They will absolutely be prejudiced under the same doctrine that the court raised regarding the other issue that we discussed. We know that, of course, because our claims for punitive damages certainly fall within claim preclusion. The punitive damages claim involves the exact same parties as the wrongful death claim and the emotional distress claims. It arises out of the very same transaction or occurrence, and this trial is going to settle that matter. It'll be resolved on the merits after we turn it over to the jury, and they won't get a chance to bring that claim for punitive damages again. It's a derivative action, Judge. It actually doesn't even stand on its own. It's a derivative action that depends entirely on the suit, and this is it. This is their one shot. If we go back to comparing what governs these various counterclaims, I just talked about Rule of Civil Procedure 13 that governs counterclaims versus Idaho Statute 6-1604, which governs punitive damages. Unlike defendant's motion that was potentially required to be filed with their original pleading, if it was compulsory, or can be filed later, plaintiff's motion was not even allowed to be filed with their original pleading. The statute says you cannot add a prayer for relief or punitive damages in your original pleading, in your complaint. You have to file a request for leave to amend the complaint later, at a later date. Further, Section 6-1604 sub 2 states, a prayer for relief added pursuant to this section shall not be barred by lapse of time under any applicable limitation on the time in which an action may be brought or claim asserted. Judge, I want to reemphasize that. Under any applicable limitation on the time. And Your Honor, again, with all due respect, I would assert that that includes court scheduling orders. This is not to in any way state or imply or infer that scheduling orders are unimportant. I'm not implying that whatsoever. They are important and they need to be followed in all cases. My argument, Judge, is that a motion for punitive damages stands outside of the scheduling order because of the gravity, because of the importance of it. We know that motions for punitive damages or leave to amend for punitives are generally disfavored by the court and only allowed in extreme circumstances. But when those extreme circumstances are present, when the evidence is there, they are treated with extra deference because of their nature. There is a purpose for punitive damages, and it is to punish and prevent and deter future similar behavior and future conduct. The court looks at them, Judge, as disfavored generally. In other words, they don't want people bringing punitive damages all the time for any little thing, of course. But when the evidence merits it, they have special deference, and that's why they're not time barred by anything under the statute. What that means, Judge, to my understanding, my reading is, as long as the complaint was filed before the statute of limitations, that's the only limit that the statute puts on the punitive damages, says it shall not be barred by any lapse of time under any applicable limitation on the time in which an action may be brought or claim asserted, if the time prescribed or limited had not expired when the original pleading was filed. In other words, if you file before the statute of limitations, then there's nothing else that dictates when the motion for leave to add punitive damages can be brought. The prayer for relief for punitives can be brought at any time regardless of any other applicable time limitation under the statute. Judge, I already brought up my argument about punitives being generally disfavored but protected in those cases where they're merited. It's also because, Judge, I think the statute is written this way because, again, it's not an independent claim but merely a prayer for relief and a prayer for additional damages. Because it's only a prayer for relief and a prayer for additional damages, it's actually not something defendants are even required to respond to. They don't even have to file a response. And if they do, that doesn't mean punitives are automatically granted. And so, in other words, filing 28 days or 30 days, 29 days before trial does not prejudice the defendants in any way whatsoever. Required to respond. They did respond, but they weren't required to do so. And even if they didn't,
that doesn't mean we're automatically granted those punitive damages. We still have to prove them up to a higher burden. Your Honor, I've got an argument here about claim preclusion. I think I've made that argument to the court. Skip down here. I made a special note, Your Honor, actually wrote it here on this filing Monday morning when the court was talking. The court said, when justice so requires, and I made a particular note of that. The court used this term Monday morning in ruling on some pretrial issues. If ever a term applied to any claim, this is it, Your Honor. I waited specifically until the end of the evidence to bring this back because of some things that I found in case law. And if I don't get to it right away, I promise I'll get to it. I'm just going to go through what I've got here.
Take your time.
This is obviously, Judge, an issue of discretion. There is no question that whether or not this motion should be granted or denied is an issue of discretion for the court. Idaho law is clear that punitive damages are not a matter of right. They're subject to strict statutory and judicial controls. The process is governed by 61604. The court must allow the amendment to plead punitive damages only if the moving party demonstrates a reasonable likelihood of proving facts sufficient to support such an award at trial. This statutory requirement is echoed in case law, which consistently holds that the trial court's decision is reviewed for an abuse of discretion. So it's a discretionary issue for the court. But Judge, as I pointed out, the court must allow the amendment to plead punitive damages if the moving party demonstrates a reasonable likelihood of proving facts sufficient to support such an award at trial. I waited until the evidence was over. We've got all the evidence in so the court can have all of that in front of it and see that we have absolutely demonstrated a reasonable likelihood of proving facts sufficient to support an award of punitive damages. I wanted the court to see that we had our evidence in and that we have a reasonable likelihood of winning on that. With that, Judge, case law is clear that the motion, no matter when it's brought, should be granted. The Idaho Supreme Court has repeatedly emphasized that punitive damages are disfavored and should be awarded only in the most compelling circumstances, such as when the defendant's conduct constitutes an extreme deviation from reasonable standards and is performed with an understanding of or disregard for its likely consequences. Judge, that is exactly what we had here in this case. I cannot think of a more extreme deviation from reasonable standards of conduct than somebody who walks up to a guy with his back turned in the parking lot who is arranging car seats for his kids, hides a gun behind his back, walks up to him and shoots him point blank in the chest, and then shoots him again as he runs away. I cannot think of a more extreme deviation from reasonable standards of conduct. And then it says, with an understanding of or disregard for its likely consequences. And the evidence showed James Brashier telling both police officers, I know what I did. I thought about it. I decided to do this. I weighed out the consequences. I thought about it and thought about it. I know I'm going to jail. He knew the consequences. He knew them before he executed this plan, Judge. There is no case that I've ever heard of that fits the parameters of punitive damages more than this one. If the moving party presents sufficient evidence to meet the statutory threshold, as I just stated, and the court nevertheless denies the motion to amend or refuses to submit the issue to the jury, this may constitute an abuse of discretion and reversible error. I'll cite some case law here for you, Judge, to think about, to consider. I imagine you'd want to give this some thought over the evening, but
I'm ready for you.
You bet. This is illustrated in Mitchell versus Baron Dreggt. It's 120 Idaho 837 or 820 P. 2nd 707. The appellate court there found error in the trial court's refusal to submit punitive damages to the jury when the evidence supported such a claim. There's also Polk v. Larrabee, 135 Idaho 303, or 17 P. 3rd 247, where the Idaho Supreme Court stated that as long as there is sufficient evidence to support the trial court's decision not to allow the jury to consider punitive damages, the appellate court will defer to that decision. But again, the decision was based on whether or not the evidence was sufficient. In fact, Judge, my point here is that none of these cases deal with a timing issue. They're dealing with an evidentiary issue. We have met that requirement to prove ahead of time, or actually during trial, both that we can meet or we have sufficient evidence, Judge. Time doesn't actually enter into any of these decisions. In this case, we've not only presented sufficient evidence to meet the statutory threshold, that we've far exceeded it. Threshold is whether the defendant acted in a manner that was an extreme deviation from reasonable standards of conduct, and that the act was performed by the defendant with an understanding or disregard for its likely consequences. I went through all that. The mental state, Judge, required for punitives is, quote, an extremely harmful state of mind, whether malice, oppression, fraud, or gross negligence, wantonness, or simply deliberate or willful. Here, James Brashier acted with malice aforethought as he decided to kill John while he was still at Rebecca's apartment, and then drove to Rosauers and laid in wait for him. Here, Rebecca Brashier intentionally sent an email to John, which was out of character for her, knowing that her father took her car, took his gun, left before her, intended to follow John, and after having told her that day he wanted to kill John, and having promised her and others in her presence that John would never get those kids. We've presented an abundance of evidence to support an award of punies. There was no bad faith or dilatory motive. Having read the statute, Judge, I did not that this would be time barred. In the absence of such motives, bad faith or dilatory motives, Judge, or any undue prejudice to defendants, as I've explained, there's no undue prejudice here, the leave should be freely granted. Traditionally, under both state and federal rules, motions to amend are freely granted. And finally, Judge, to quote the court should freely give leave when justice so requires. Justice absolutely requires here that plaintiff's motion be granted and they be allowed to request an award of punitive damages from the jury because they were not in control of the pleadings. It's a prayer for relief, not a new cause of action. Defendants were therefore not required to respond and therefore not prejudiced by the late filing. Claim preclusion will bar plaintiffs from bringing this action again, and the evidence for punitives is overwhelming. Judge, that's the argument I prepared, but in addition, I have something else for the court to hang its hat on if necessary, and that actually came from the court itself by way of the court's, clerk? Staff attorney, thank you. I'm brain burned. Judge, this case that your staff attorney brought to us while you were working on jury instructions, this case of, is it Fowl versus Comerica? Pafau versus Comerica?
132.
I have the citation here, Judge. This is something that staff attorney brought out to us, and the citation is 135 Idaho 152. The statute, Judge, is actually, this case is actually about wrongful death and damages for wrongful death, and it was brought up in regards to our debate about proposed jury instruction 24 and damages for wrongful death. However, very interesting paragraph here, a couple of paragraphs, Judge, if I might. This case is citing a 1980 case in Idaho called Gavica versus Hansen, which is 101 Idaho 58 or 608 P. 2nd 861. That case, just so the court is aware, was overruled on other grounds, not these grounds. But the upshot of that case, Judge, Gavica v. Hansen is that the court, this Idaho court, allowed or extended the measure of damages in a wrongful death action to include punitive damages. I'm on page 157 of that case right now. So they didn't even, in Gavica, from what I'm reading here, Judge, in this case, I haven't read Gavica yet, but in Gavica, the court didn't even consider punitive damages a separate prayer for relief or a separate line item of damages. It was just another portion of damages included in wrongful death. If the court wanted to follow that here, we'd be fine with that. If the court sees that that's appropriate, that's still good case law. And if punitive damages are simply included, or we're allowed to include them as another line item of damages in the wrongful death claims, that's fine. We'd be happy with that. Or if the court would reconsider its motion for leave to amend to add the prayer for relief, we're fine with that, Judge. Either way, I guess there are alternate theories. So appreciate your time. That's the argument.
Thank you. Ms. Brashier, Mast, do you have any additional argument that you want to make?
I do, Your Honor.
Go ahead.
So I would say this, that the plaintiffs had plenty of time to bring their punitive damage claim. It's easy to say that the counterclaim is different than the punitive damage claim, and it's easy to bring a lot of fancy case law and a lot of information like what they're bringing and saying that's different, but they had time and they didn't file their paperwork. It's easy to say I'm going to fall on my sword. They had time to do that. They knew that this case was coming and they didn't file it expeditiously. The second thing is that I did file an objection to the plaintiff's motion for leave to amend. I did include that Idaho Code 6-1604 that he mentioned. And I do believe that he did not present clear, convincing evidence at the trial. He mentions that my dad shot John Mast at point blank and shot him once in the chest and 3 times in the back. I don't deny that. My dad definitely did that. It's something that is not arguable. However, when it comes to myself, he did not present clear and defining evidence. An email sent to John Mast when I was ordered to directly communicate for the first time in several years is not an answer for proving that I had anything to do with a murder. I was doing exactly what the judge ordered in that state. I was following my attorney's advice, and I didn't have anything to do with it. I arrived on time at the scene as indicated at 6:02, which even his own family and backed up. That's not evidence of a murder. That's not enough to go off of. You have to present clear and convincing arguments. There was no witnesses at my apartment that they corroborated that stated that I made claims or threatened or was involved in anything. There was never any witnesses that they brought forward that could say that I was a violent person. There was nothing leading up to me committing any acts of violence towards John Mast. I had absolutely nothing to do with it. I took my kids to a visit at 6:02, as I said I would, and I arrived on scene. Now, he also mentioned that my dad made a statement to Detective Crane that I heard him say something to the effect of that he would kill John Mast or something to that effect. As I testified, if he said something to that effect, I didn't take it seriously because I'd heard my dad say that kind of a statement convincingly in a way that was just an offhand the cuff kind of, oh, I can kill the guy. It didn't mean anything to me. I didn't think that he would ever kill him. I never took it as a plan or a motive or anything that would have possibly harm someone. If I would have done that, I would have made a phone call. I would have alerted law enforcement. There has to be clear and convincing evidence in order to award punitive damages. They didn't come up with anything that was clear and cognizable. They came up with an email that said that I would be there on time. That's what they had. A parent arriving at a visit when it was ordered by a judge. How is that a motive to kill? And they ran all around telling everyone that I killed him. And yes, I have to take that to another court. I understand that. That'll be something for another day. And I recognize the court, and I actually respected the court enough to say, that's fine. I'll take that up another day. And they bring their thing up one more time. Your Honor, that's what I needed to say.
I appreciate it. Thank you very much.
Thank
Mr.
you.
Brashier, do you have any
I do
argument?
not, I do not, Your Honor.
Mr. Miller, I think for the sake of argument, because I haven't ruled yet, but as I'm going through this and I'm looking at two things come up. Number one, if the court grants your motion to reconsider and allows the amendment, the argument for punitive damages, how do you envision this? Punitive damages as to each defendant individually? And the reason I say that is based on Ms. Brashier's argument, because I can envision, assuming we do this, a situation where they could find Mr. Brashier's conduct to justify punitive damages, but not Ms. Brashier Mast. And so how do we differentiate that, or do we differentiate that? This is, I will confess that this is a matter of first impression for me. I've not been through this before.
Well, Judge, I think that, I appreciate that. I think that we'd want to treat it the same way we've treated the other counts, right? Where each one of them, the jury's going to find out or decide punitives as to each one individually, right? And if yes, then how much, and if no, then move on. I would think we treat it the same as the others.
And again, just for the sake of discussion here, that's how I would intend to do it if I grant that, because again, I think Ms. Brashier Mast brings up a good point.
Sure.
That if they impute this as to her father, we don't know whether that's been imputed as to her or not, if it's just a single line item. Okay.
No, I think that's fair. I think that'd be the fair way to do it, Judge.
Okay. Now, the other issue I want to bring up is I'm looking here at the stock jury instructions for punitive damages found in IDJI 9.20. The first one reads, if you find the defendant's acts which proximately cause injury to the plaintiff for an extreme deviation. Now we have the term proximate cause in there. If this happens, I will re-add that instruction for proximate cause in there, because I think now we have the term proximate cause showing up.
And I think that would be appropriate, because now we have proximate cause in the instructions somewhere that needs to be defined. I agree, Judge.
The other thing is we talk about clear and convincing evidence. When I was preparing instructions for fraud, that was the other part of my weekend that kept me alert. Fraud is also proven by clear and convincing evidence as well. So there is a stock instruction that talks about clear and convincing evidence.
Okay.
Okay. I'm reserving a decision on that. I will be prepared tomorrow morning at 8 o'clock when we meet to address that. If I grant your motion for reconsideration, what I will intend to do is, I think I have to add these instructions as best I can together with those additional ones.
I think so.
Again, I'm not saying yes or no right now. I want to review this. But again, I think Ms. Brashier Mast brings up some good points that I want to take into consideration as well. Okay. Anything else that we're missing tonight?
No, Judge, thank you.
The hour is late. Again, I appreciate everybody's patience. let's, I'll be prepared again, like I said, at 8 o'clock tomorrow. We'll start off in courtroom 5. Well, I guess we'll continue the progression to the west, as it were. So I wish everyone a good evening. I appreciate that. What I may do is, I think I've got email addresses for everybody.
Ms. Davenport has mine, I know that.
Okay. What I may, well, we'll get together tomorrow at 8. I think we can work this out. But I've got those in the event that I need to communicate with everybody by email this evening. I'll do that if I've got some questions. So I suspect that your preparation hasn't ended for the evening, nor has yours. So, but I wish you well, and I'll see you back tomorrow morning at 8 o'clock.
Thanks, Ronald.
Thank you.